Yes, ma'am.
Third can be accommodated. What is your good name?
Draupadi Mahanti.
Your name?
Draupadi Mahanti.
The request of Ms. Draupadi Mohanty and council appearing on instruction of Ms. Chitra Pari. You are the petitioner yourself. Is the request of the petitioner person. Let the matter be listed on 23rd of August 2023.
Page number 2, item 5 to 10.
Your
Page number
Lordship,
3, page number 2, item 5 to 10. Page number 3, item 11. Page 4, item 12 to 18. Page 5, item 19 to 21. Page 6, item 22 to 26. Page 7, item 27 to 30. Page 8, item 31 to 35. Page 9, item 36 to 40.
I may be pardoned, Lordship. I am through virtual mode, Lordship. With Lordship's kind permission, item number 36, Lordship. I am for the appellant, Lordship. I pray week time, Lordship.
18th of September. At the request of Ms. T.S. Mohanty. In 1933, 36, okay. 36. All right, Mr. P.S. Mohanty, Ms. P.S. Mohanty, and counsel, appealing the instruction of Mr. S. Senior Counsel. Let the matter be listed on 18th September 2023.
Page 10, item 41 to 42. Page 11, item 43 to 48.
I'm one of the party. One very Lordship to get up this matter. If there is order is there, favor of the petition, continue. Concept pages.
48.
48.
The request of Mr. Kalim Nanda. We are appearing for which opposite party, Mr. Nanda? You are appearing for opposite party number 9. Mr. Kalim Nanda, also appearing for opposite party number 9. Let the matter be listed on 18th of September 2023. Meanwhile, interim order is passed earlier, shall continue.
Page 12, item 49 to 54. Page 13, item 55.
And pardon to make a method of board will not be. Here, whether it's addition of 170052, it is a case where the petitioner is one the accident of displaced fully of Mandira Dam and effort for restriction brought on from one.
All right, it will be taken up on 23rd. Just give the slip.
Just one, Mr.
And another is the PIR matter where the land was
All right. Huh?
Dispense family only dispense. नहीं land acquisition से तो हम यहाँ bench single division bench है तो है.
It is not the land acquisition lot. The thing is this matter was earlier before my lord and your lordship when sitting in a division bench in the state we Mahantin lot, and the matter was directed to be listed on 25/9/2022 with removal of the defect. I removed the defect.
That is because we were taking up land acquisition matters.
One settlement was coming. No civil matter.
Also list before the assigned bench. Give the list.
My lord, one writ appeal 1615 of 2023. May this matter may be
When
taken.
that matter has been filed?
2023. Before 3 to 4 months. Fresh admission for the writ.
Or you just But have you not seen the notice printed in the top of the cause list that this matter should be mentioned before the deputy registrar bench? Judiciary.
Already mentioned what this.
All right, just read.
Can I seek your lordship's kind indulgence? Can I seek your lordship's kind indulgence? It's a writ application.
It says that if after mentioning before them, the matter is not listed. No, that is why it go to the DR, no? Right. Keep the date, there is no urgency in these matters. Yes,
As a petitioner, they are the entrepreneurs. They are running the telemedicine shop under all over the Odisha. Now, in the 2015, the state has stayed the operation of their nodes. Now they have filed writ application. This honorable state that now up to that they have went to Supreme Court. Honorable Apex Court has modified the order and ordered that all the nodes which are in operation will be operated. Now, in the meantime, they are operating the nodes, but they're not getting their wages out of that, your lordship. For that, I'm issuing for your lordship. The lead case is WPC number 1769/2015. Any date, your lordship. Please.
Sir, they-
Single bench or division bench?
Division bench, your lordship.
Division bench.
If directly, directly to find a note, you can look. You might have contact, I can find it out. One day, 31.
listed one, only for filing notes. Just listed one. It is 41,
Item 41.
listed Monday.
At 2 p.m.
Yes, sir.
DN
DN Roads.
for the opposite party.
All right.
I may be pardoned, my lord.
Inform the council for the appellant.
Monday 2 p.m. so I can find.
2 p.m.
I may be pardoned, my lord. Respondent number 1 is a
Only 2
85-year-old old man and deprived of his pension, my lord. The board preferred an appeal, being appeal number 111 of 2019, my lord.
What happened?
He is not getting any pension, my lord.
Take the matter into thought.
Obliged, my lord.
I am for the capital state has preferred the rate of matter regarding termination of service.
The caveator is mentioning for listing the matter. It is unheard of. When the matter will be taken up and without giving you notice, no order will be passed. So just don't take back this mention memo.
Beg pardon to mention, my lord.
All right.
Beg pardon to mention, my lord.
I'm allotment.
Rate appeal 682 of 2022. It's a matter regarding that in a pendency of a criminal trial, a disciplinary promotional will be upheld. Short. The government, my lord, had preferred this rate appeal. There, my lord, the government stated that the respondent petitioner, who was the petitioner in the rate, is dead, my lord. However, we are alive. So I have filed a IA to recall that order, my lord.
All right, we'll take it up. Take it 27th. Matter 20.
So Kuntia, you check.
Either 28 or 29.
Because otherwise your file will have gone to some other building.
Thank you. Supplemental list, fresh admission item number 2.
May I please, your lordship? The appellant was initially joined as junior clerk in erstwhile Civil Forest Development Corporation on 7/2/83. One Ramakanta Mishra joined after 3 years of the joining of the appellant. His services was regularized during 1992.
Have you removed the defect in terms of the earlier order?
My lord, remove the defects.
Because earlier order,
My lord, remove the,
no, because
there is no noting for
no, there is no notice.
what I removed, my lord. My junior,
Because regarding the removal of the defect number 5E, it is also mentioned in 1st of August 2023, there is the
Your Lordship,
defect and has not.
I'm sorry, my lord, permit another chance.
Already on 28th, it will come again, 28th of August. List on 28th of August. If any defect is to be removed, such defect shall be removed by the next day. Yeah, Dr. J.K. Lankal and the council has appeared to the applicant. All right. You just check up only one defect that is showing,
Mine.
5E.
Sorry.
Yes.
Item number 3.
Your losses. My lord, in the repetition, I have challenged the annex 5 on at page 36, my lord. Your lordship can.
Okay, then they'll call.
Mr. Lenka,
So come back.
Dr. Lenka. please
Just
come.
Mr. Mohanty, just there, because
my lord.
there is a
I'm-
small note is there. You are correct. There is a small note at the fag end of the paper that defect has been removed. So you make your submission without unnecessarily passing an innocuous order. Make your submission. Score over the top.
My lord, only.
The crux of the case is that when the writ petition was filed, the petitioner, writ petition has already superannuated.
My lord, the honorable single judge held that since the petitioner has already been superannuated, the employer and employee relationship does not exist.
So only this court can examine the matter if you can show that there is a scheme for regularization and he was entitled to be considered in view of the scheme. Otherwise, he is absolutely right.
My lord, the junior to the petitioner has been regularity. Similarly situated employee filed writ petition before this honorable court. This honorable court held that since the junior to the petition, very junior, has been regularized. That has not been considered.
We just come to that order of regularization of the junior.
Your lordship, annex of
Who is appearing for the state in this matter?
page 20.
Mr. Muduli, are you appearing?
This is Odisha Forest Development Corporation.
Oh, it's a corporation. All right. Where is the order?
Annex 3, page 20, my lord.
He was also like you as a contractual employee.
That is junior clerk, man.
He's also,
Like Ramakanta.
what is the appointment date? Both as the same situation.
Ramakanta Mishra was also, your lordship kindly see annexure 1, my joining, my lord.
Annexure 1.
1 page 18, my lord.
Annexure 1 is your joining report.
Joining your report, my lord.
But what is the list by which they have been engaged?
No appointment is letter was issued so far as the petitioner and Ramakanta Mishra is concerned.
Now tell us how to determine who is junior and who is senior if there is no document.
Ma'am, because the petitioner was appointed in 83, he was appointed in 92.
What is the record? 92, he was brought to the regular establishment. That the
92, that Ramakanta Mishra brought on the regular establishment.
yes,
My lord.
but we do not know when he was appointed.
Before this honorable single judge, my pleading was there, he was appointed, that was not denied, my lord.
Yeah, denial is not, you have to prove by the primary document. Regarding employment, there cannot be on the basis of the denial.
And he filed, my lord, he filed representation for appointment. Was Ramakanta Mishra, your lordship kindly see annexure 2, page 19. First time he filed representation for appointment. Page 19, my lord.
Yes.
This is the representation of Ramakanta Mishra. Instead of my lord regularizing my services, they terminated me my services. And I went to the labor court, my lord. Labor court held that junior Ramakanta Mishra was regularized, ignoring the claim of the petitioner and directed for reinstatement without back wages. Against that order, I went before this honorable court, and this honorable, for so far as back wages are concerned, and this honorable court held 30% back wages.
But it appears 21st May 1985, Ramakanta Mishra was also serving. Your claim is not true that it's only serving from 1992.
Your lordship, kindly see the
document you are relying that shows that.
Judgment of the minor.
Labor court.
Labor court award, my lord. That is at page 42, my lord. Page 42. Second para. May I read, my lord? In the case in hand, it is not disputed that Ramakanta Mishra was regularized in the year 1992 by the management. It was specifically stated in the written statement that since the workman had not raised any objection when Ramakanta Mishra was regularized in service, he cannot challenge the same, and this indicates that the OFC Limited has regularized the services of Ramakanta Mishra.
Yes.
Mishra, who joined services on 23/6/85, and his services was regularized in the year 1992. Ramakanta Mishra was not only junior to him, but his services was discontinued on the ground of a misappropriation. He made representation, but the management did not pay any heed to it, so that workmen made representation to the management when Ramakanta Mishra was regularized in service. So the averment in the written statement that the workman had not raised any objection at the time of regulation of service of Sri Ramakanta Mishra does not appear to be true one.
Yes.
Therefore, that findings they have accepted and they implemented the order. My question is, my lord, since one Saroj Kumar Sahu, my lord, filed writ petition showing very Ramakanta Mishra for regulation, and this honorable court allowed regulation.
Where is the judgment?
That is the before the honorable single judge. At page your lordship kindly sees. At page, my lord, 81 of the honorable single judge writ petition, my lord. Saroj Kumar Sahu, double OJC 1514 of 1998.
You're referring to page?
Page 81 of honorable single judge writ petition, my lord. Writ petition of honorable single judge. That is judgment in OJC number 1514 of 1998. Annex 20. Relevant para is para 7, my lord.
Let me check.
In the corporation, is there any pension?
No pension, my lord. Only in case they regulate my services, I will get some gratuity. Otherwise, I will not get any benefit, my lord.
All right, we are admitting it. Heard Dr. G.K. Lankal and counsel appealing to the appellant. By means of this intercourt appeal, appellant has challenged
Order annex.
has challenged the order dated 2/3/2021 as passed by the learned senior judge in WPC number 8081 of 2006.
2008.
8881.
Of 2008.
No, 2008. 2008. 8881, 2008. By passed by the learned senior judge. Mr. Lemple and the council has submitted that. His appointment was not challenged, but they made the comment that one Ramakant Mishra who had been regularized by the office order dated 16th January 1992, Annexure 3 to the memorandum of appeal was juniored to the appellant in the contractual engagement of junior clerk under the Orissa Forest Development Corporation Limited. So, at the time of regularization of Ramakant such and such, Mishra, the case of the petitioner was not considered. That was a hostile discrimination, as Ramakant Mishra was not regularized by any first selection process. On that basis alone, the finding of the land sale judge has been challenged. Admit the appeal to be heard on merit. Issue notice is made returnable on 27th of September 2023. The attorney shall take steps for service of notice on the respondents by registered post with AD respondents number 1 to 3 by registered post with AD within 3 working days. Mr. Lanka, how have you incorporated 4 as the respondent in the appeal?
My lord, your lordship kindly see, I have included respondent number 4 as respondent opposite party number 4 in the writ petition. But on the wrong submission of the
Unless that order is recalled, how can you make?
I filed petition for recalling the order. The order was the honorable single judge did not consider the said aspect.
Then now how can you file an application for impleadment? That is one thing.
Mine.
And against him there is no relief also.
But that my petition was pending, but not considered, my lord. And finally the matter was disposed of.
But you cannot yourself plead because his name was deleted.
Your lordship is right, your lordship.
So we are not issuing notice of file.
My lord.
We delete the respondent number 4 as the respondent number 4 was opposite party number 4 in the writ proceeding, and his name was deleted by an express order. So, however, the appellant should be at liberty to file an application for impleadment at this stage also. All right.
Item number 3.
Legal losses. Only do you lordship kindly come to
No, at liberty.
kindly come to page 36, my lord, of the brief. Annexure 5. I have challenged that rule in the before this honorable court, before in the writ petition. And only sole ground is that the power has not invested that with the register to frame this rule, as section 33B has been repealed from the Cooperative Society Act.
Who is appearing for this? You are appearing for the
Your
response.
my lord, this matter, in fact, my lord senior ought to have pointed out the honorable single judge that the matter is assigned to the division bench. Well, in fact, this rule under annexure 5 is under challenge and it was listed for the honorable single judge. My lord senior ought to have pointed out the honorable single judge, no, this matter is assigned to the honorable division bench.
I have also
And it is
assigned
asked-
my, I have also pointed out that, but it was taken up.
No, it has not been
No,
reflected.
this is during the vacation, my lord.
This is a writ appeal.
This is a writ appeal against the interim order. No interim order was granted that it is abide by the result of the writ petition, my lord. When the power is not vested with the register on the act itself, my lord, then the rule is a nullity in the eye of law at the petition. Cannot exercise this power from this.
That will be finally decided.
My lord, that
Nothing has been decided.
my lord, they have given effect to 1/6/2003.
No, just we.
Now they will do the recruitment and will, but service condition of the chief executive will be governed by this rule, my lord. Your lordship kindly see
You are for the writ petitioner.
it petitioners, my lord. Our service conditions should be governed by law. When that power is not vested with the register, how would you frame the rule, my lord?
You come to your this prayer in the writ petition.
Writ petition prayer, my lord.
Yes.
Prayed, my lord. The petitioners most especially pray that the honorable court may be gracious plead to allow the issue a
So,
writ
Mr.
or dice in
Mudali,
the
there is
nature of
no
such a
challenge to the rule. It is a challenge to an executive order. You just read the prayer. The your submission also not correct.
or quashing, my lord.
They want the common cadre constituted by the chief executive officer of tax, SCC, lands, etc.
That is at page 36, my lord, we can see.
Huh?
That is at page 36.
No, I'm just looking at the prayer of the writ petition. Look into the prayer of the,
That document, my lord, we can see.
this document is
Page
What?
36 of the writ appeal,
date 25/2020, 2003.
yes, 25, 2020.
Let me place that in exercise of powers conferred upon me under section 33B of the Odisha Cooperative Societies Act 1962. I, Sri Uddhava Chandra Maji, IS, Registrar of the Cooperative Society Odisha, do hereby prescribe the rules called the common cadre of the Chief Executive Officers of Tax, SCS, LAPS, and FSCS rules 2023 as enclosed herewith. The said rules shall come into force with 1/6/2023. Entire service conditions have been provided to be governed under these rules, my lord. You lordship kindly see that 33B has been repealed by Act of 11 of 2004, my lord.
Tell me the rule.
If power has not been vested under the statute, my lord, how can it be ruled? Now we will suffer, my lord. Unless it is stated, my lord.
Oh, that is the rules.
In the rule, recruitment is there, my lord. Disciplinary action is there. All
Mr.
happen.
Mudali, that we observe that this since the matter is relating to the division bench. We just set aside the order of the learned single judge and ask the registry to list the matter before the appropriate bench.
It is not the ground of challenge. No, that is not
No,
being
that
said.
is on merit, but in the prayer, I find this, I initially thought it is an executive order, but it appears that the rule has been made. Paragraph 2 of the appeal memo, my lord,
Yes.
specific government that rule has been challenged.
No, in the prayer of the writ petition also rule has been challenged. Only problem is in his filing sheet, he himself has written single judge matter. So it has been tested in the vacation before the single judge. That is the problem.
Heard Mr. M.K. Mohanty, learned counsel appearing to the need of the court.
And nothing is written regarding
Though
point
this
of.
intercourt appeal has been filed to challenge the interim order,
No, that is the letter. Copy of, which is the order?
The order is at page 52, my lord.
52.
Annexure 6.
As the interim measure, it is
Yes,
directed
yes,
that any
No, I had
decision
opened
taken
the
personally
restriction.
included by the
Annexure.
officers shall be abide by the
Challenge the interim order dated 30th May 2023,
Annexure 6.
delivered in IN number 8081 of 2023. So, by the said order, Plant Single Judge is observed as follows. As an interim measure, it is directed that any decision taken pursuant to the interim impugned order by the initial file shall abide by the result of the writ petition. So, on a wider scrutiny, we find that by the writ petition being WPC number 17604 of 2023, the appellant has challenged the common cadre of civil chief executive officers of PACS, SCS, LAMS, and LAM PCCS and FSCS rules 2023, promulgated by the order number 9583 dated 25/2023. Stop. As such, it will come under the assignment of a division bench of this court. Hence, we set aside that interim order as challenged, and also direct the registry to list the matter before the assigned division bench for consideration of the appeal. The appellant is given liberty to move the interlocutory application seeking the interim order before the said bench. In terms of the above, this appeal stands disposed of. Come, because it's a transfer. I just mentioned before. Mr. P.K. Mudali, and counsel has approved. Hold the next.
Item 4. May I please, Lordship?
Okay.
My lord, the petition engaged senior counsel from Delhi. She is on another government pass over. My lord, the petition engaged senior counsel from Delhi. She is on another government pass
Mr.
over.
Counsel, what mention are you making? You can ask for a passover.
Pass over. Pardon me.
Not today, it's not possible today. He will come within at 12 in this court.
Can he come to this court at 12 p.m., 12 o'clock? Because we cannot wait for a counsel. This court is still 1. After recess, there is no court. So if he comes at 12, can take up.
Or we can give you another date.
On Monday, on Monday. No.
Not possible. It will go to the month of September.
My lord, no, infectious. Otherwise, the matter is infectious, my lord.
Do it.
Then for you, yourself do it.
No, but
You do it.
my lord,
Yes. You do it right now.
my lord.
Make your submission.
Pass over. But
All right.
Item number 5.
May it please your lordship. Your lordship, the present petitioners have approached this honorable court challenging the action of the opposite parties in constructing a ring road over a playground, Your Lordship. The impugned playground is situated in Tamando, Bhubaneswar, Your Lordship. The opposite parties have taken a decision to construct a ring road from Tamando Square on NH 16 to Paikarpur in Khordha district, Your Lordship. So what the present petitioners are praying is that we only seek for a realignment of the road. We are not against the construction of the said ring road on that area.
Consider the.
My lord, she is not placing the entire facts.
Your Lordship, if I may be.
PIL was filed. Your Lordship directed the concerned department to consider his representation. That was disposed of. Hide impugned order annexure 9 at page 58. Your Lordship,
Yes,
it's
Your
not
Lordship.
a very
That
small
is there on record, Your Lordship.
for to utilize a playground by a club. Club is the petitioner. They want to realignment of the entire ring road, and what inconvenience
Lordship,
will be caused. Just
that
a minute.
entire
That is-
realignment is not what has been prayed for, Your Lordship. Your Lordship
Perhaps
may
you do
look
not
into
know. It
page
wants
number 58, Your
realignment of
Lordship.
a portion amounts to realignment of the entire road.
You know
That
what
I
is
will place
the
it.
shape
Yes, Your
of,
Lordship.
shape of the ring road?
Your Lordship, that
Yes,
is, we
yes.
have annexed all the relevant documents.
Annexure 9 may kindly be.
Annexure 9 may kindly be.
Order.
Yes, Your
Basis of that order, this administrative order has been passed. Can you show us the earlier order passed in the writ petition?
Yes, Your Lordship. That is at Annexure 8, Your Lordship.
All right.
Your Lordship may look into page 57, Your Lordship.
Report was called for thereafter it has been dispersed.
May I take Your Lordships to page number 58, Your Lordship?
I have read the entire order. Now make your submission. After that, how can you come under the garb of a public interest
Yes,
litigation?
Your Lordship, why we have filed this public interest litigation is, Your Lordship, if that there is sufficient land in that particular, under that particular plot, Your Lordship. If the ring road is constructed within that area, there is no place there where people can exercise their sports and recreational activities, Your Lordship. The Mando Mini Stadium remains the only mini stadium, and that has been sponsored by MP-led funds also, Your Lordship, in that particular area also.
They have
Also,
considered,
Your Lordship,
all the aspects has been considered.
Your Lordship, what my submission is, Your Lordship, if Your Lordship looks into it, page number 58, despite the court order, the opposite party has said that whereas if the alignment is changed, all the design parameters relating to the geometry of the road need to be checked, Your Lordship. They have passed this order without checking the geometry. That is evident from page
Don't stop
58, Your
there.
Lordship.
Don't stop there. Again, need to be checked for
This
the
will-
changed alignment. No, no, it's not a small thing. The entire
Your
alignment.
Lordship, we
is
agree
already
it is not a
over.
small thing, but also, Your Lordship,
for
the
a
entire
small-
area will be devoid of something that that is otherwise also they cannot exercise their right to sports and right to recreational activities, Your
There
Lordship.
are many
That
stadiums
we are
in
not
Bhubaneswar.
totally against the construction of road. What we are saying is they have vacant road over there, Your Lordship.
No, no,
Vacant
this is
land
a-
is there.
a highly technical matter. The court is not sufficiently has expertise to decide all these matters.
Yes,
We
sir.
leave to this authority and the learned single judge while passing your ordinary writ petition. Now you come under a garb of a public interest litigation. That itself shows that you are not very fair to the court.
Your Lordship, that is why we have
Issue
mentioned
has
the
been
writ
decided.
application.
Issue has been decided. Whatever the order could have been granted to you, that has been already issued by the learned single judge. An exercise has been taken. We cannot see it over the decision of the government in this matter.
Your Lordship, all we that is seek for is not sitting over the decision, Your Lordship. All we seek from this court is if the opposite parties can apply their minds again, Your Lordship.
Have
Because,
we come to an inference they have not applied their mind?
Your
According to-
Lordship, because,
According to the petitioner, we have not applied our.
no, Your Lordship,
Your
it
Lordship
is not the
is-
case, Your Lordship.
Order, everything has been analyzed, everything has been assessed, and ultimately the concerned authority has come to a conclusion, it's not possible. Because we cannot realign, it is already, money has been transferred, land has been acquired, everything.
That has not been done. That has not been done, Your Lordship.
How
That
can
land
you
has
say
not
so?
been acquired. That is what we are saying. Only it will take some extra effort on the part of the opposite parties, Your Lordship. They are themselves saying that needs to be checked for the changed alignment, Your Lordship.
No, after that, they read the next part of the order.
And they also say that this will lead to further acquisition. All those steps have not been looked into, Your Lordship.
Are you
All the-
sure that no acquisition? has
Yes,
been-
Your Lordship. Yes, Your Lordship.
Your Lordship may see.
Your Lordship may look into the map
page
also that has
58,
been
last
annexed, Your
paragraph.
Lordship.
And whereas land acquisition for the private land has already been done by the Bhubaneswar Development Authority for execution of the aforesaid ring road. Her statement will be accepted and this is the order of the government. Government is saying that the tender for development of the said stretch of road so and so has already been invited by Chief Engineer DPI Roads by administration so and so, an amount of rupees 49.82 crore, and now the tender is under process.
Mr. Mohanty, you just request the chief engineer, DPI and roads of the works department to appear before this court on 23rd.
Yes, ma'am.
All right. Let us see from him, and also he should make the necessary preparation about these changes and what will be the impact and other thing, and thereafter we'll pass the order. All right.
He will appear before.
Yeah, yes, because he is a technical person. He
Yes.
can elucidate the matter better.
The information,
Uh,
what they have referred to in the order, with that
He will
information he'll
form
come.
the entire records.
Shall and
We
consider
will
paying
place
for
the records.
Petition. Also heard Mr. D.K. Mohanty, Learned additional government advocate appearing for the state opposite parties. We have also noticed that the petitioner has approached this court by filing a writ petition earlier being WPC number 06100 of 2022, where this court stopped while disposing the said writ petition. This court had observed that
Chief Engineer,
the
DPI
Principal
and
Secretary
roads.
Works Department, Government of Orissa, to take a lawful decision on the representation that was filed with the petitioners. We will make it an extra 5 series of that writ petition. It was also directed that the plan of the ring road shall be finalized. Stop. It's not a PI. Stop. Despite that order, the petitioner has filed this writ petition in the garb of public interest litigation, seeking a directions to avoid the playground under the control of the petitioner from the project of the ring road. We would request the chief engineer, DPI and roads works department, Government of Orissa, to appear in person to elucidate the difficulties they have expressed in their order dated 9 March 2023, annexation 9 to this writ petition. A copy of this order be supplied in the course of the day to Mr.
Today it may be supplied.
Government advocate.
25th better, next Friday.
25th.
Yes, next Friday.
25th.
Much
Let's see. But it is a very difficult case. You also properly prepare because you have made a very blunt statement. There is no accusation.
Your Lordship.
Your Lordship has recorded her statement that
Yes, Your Lordship.
she has submitted there is no accusation as on date.
No, we have not made. You take the instruction.
Okay.
She is making submission on the basis of the instruction given with
No,
the
that is
client.
also not pleaded in the writ petition.
That is
what
why
I'm
she is
saying.
making the submission on
She is
instruction.
making the submission which is beyond her pleading.
Now that is why that you bring
But-
out that, and she also bring the records. by
Yes,
the
Your Lordship.
decision.
My lordship, kindly imagine this, these are not so easy thing which my learned friend is saying.
And that is why the person, you also don't understand whether it is an easy or complex thing. She also doesn't understand, and we are more or less understandable.
Your
That is why someone we are summoning in the court can shed some light. That's all. All right.
Much obliged, Your Lordship.
Item number 6.
Wait, please, Your Lordship. This matter was listed, Your Lordship, earlier
Yes.
prior to my amendment incorporating the challenge of virus so far as Rule 23A, Sub-Rule 2, H and I and G and H and I, my lord. But here two grounds on which actually the writ application is filed. Number one, those provisions are not applicable to the petitioner's case because he has not defaulted or deliberately avoided to pay the water charge.
That is item number.
So relating to Irrigation Act and rules.
No, but no, you are mentioning it is a writ appeal. It is a writ petition.
Writ petitioner.
Had been asked to check. This is that case. Whether it should be listed before us. Is it that case?
No.
It's another case.
That case,
That case.
Sir, after I amended the writ application incorporating the virus of the statute.
So that.
No, it's
It was initially a single judge matter, my lord.
yes, right.
Your Lordship directed the matter to be listed for the appropriate bench. And I filed an application incorporating those amendments. That was allowed and subsequently now it is now assigned to Your Lordship.
Mr. Mishra, why, according to you, these provisions are unconstitutional?
Not applicable, reason being that if Your Lordship looks at the
On
provision
the
first.
ground of ultra-vires.
Right.
Why?
But I say this is not applicable to me, but it says that if a person intentionally or deliberately avoids to pay or did not pay in spite of demand, then the question of penalty will be arises. This penal provision can be only made applicable if somebody intentionally avoids to pay and violates the statutory provision. Then only that is applicable. But here in this case, I have never violated at any point of time. This is one ground number one.
Then what is the question of ultra-vires? You says this, there can be, for ultra-vires, you have to challenge the competence of those who have framed the.
But I also challenge the same, the
The
constitution.
problem, Mr. Mishra, take one stand. If you take simultaneous stand,
For the time being, Your Lordship may hear me on the question that non-applicability.
that is why, if it is a question of non-applicability,
Correct.
remit the matter back to the learned single judge. That way they apply, because
I understand all because I have entered into two agreements with them, Annexure 10 and Annexure 15. But both the agreements, the provision of the statute was incorporated, I have signed it. But the question is now I have to challenge it because they are challenging the interest, penal interest from 2010 till today they are charging in spite of my regular payment of the regular bill.
That is this is a dispute relating to the accounts, how the rule can be affected by that kind of a decision.
The rule also is, but the question of virus is there because
How? First of all, according to the 2022 Supreme Court decision, even if you agree to comply with the rule, subsequently when you are affected by operation of the rule, you cannot challenge that rule.
So I am conscious about it, Maran. I am conscious about
That is
it.
the estoppel will come against
So
you.
that is the reason why I say I'll confine my argument for the time being with regard to the non-applicability of the rules so far as I'm concerned.
No, you have to make your position very clear, because if you do not challenge the rule, I'm very straight about this matter. We'll remit the matter back to the learned single judge. If you challenge, you have to convince us how it is ultra-vires.
Yes, I'll satisfy that also. I'll satisfy how it is ultra-virus.
Make
But
your
this-
submission.
But the charge they are making is in relation to groundwater. For groundwaters are obtained by borewell. But there is no statutory provision for imposing tax on the groundwater. But I am utilizing for industrial purpose, no doubt. They have asked me to pay the tax and the fees. I have paid that. In spite of that, I have applied for them for the permission as per their request. I have paid it. I have applied. They have granted me permission for 6 months. Then they again forced me to apply, get water from the surface water like from a river or a Jura. Then again, I made an application, annexure 15. But law says if I make an application on Form J, they have to do it within 6 months. They have granted me permission for 6 months to utilize. I have made an application. They have to dispose of my application within 6 months. What they did, kept it till 2017, even though I have complied with everything. In 17, they granted me the permission that yes, surface water you can take now. So this period, I have never violated. But then the statutory provision is not applicable to groundwater. That is one of my basic grounds. Every family, if your lordship knows, they have got a borewell.
Entry 17 of list 2.
What is the act?
Of the constitution.
Uh-huh.
List 2, entry 17. Water, that is to say, water supplies, irrigation and canal.
That is the enabling provision.
Yes.
Have you framed any rules or
Yes.
brought any act?
The statute doesn't say. They have incorporated in the rule, but rule also doesn't say about groundwater.
Show us
Page 50, page 52 is the rule. 23A.
Page 52.
Yes, 5 running page. Paragraph 4, that is amended rule 23A.
52, this is a communication.
No, it starts from page 51. Odisha Gazette.
No, you're wrong. Maybe some other.
Yes. I'm placing the consolidated copy.
Have you filed the consolidated copy of the?
Yes, I have filed the consolidated copy.
Just for the time being, can you see it? You are referring to
23A.
Yes.
Trial of water from government water source.
This is not the government water source.
Yes.
How? They are extracting the groundwater. Groundwater is not the government water source.
There's a borewell.
And they're extracting it by a borewell. You can impose restriction, no doubt about it, regarding use of the groundwater. But unless the restriction is there, you cannot say someone is defaulting and fail and impose the penalty for that.
I will obtain instruction as to from which source they are drawing the water.
So it is borewell, admitted fact borewell.
Because this section 4, subsection 6A is clearly defines what is the government water source.
Definition,
means any water source created naturally or otherwise by collection of the deposit of water at a fixed place, any subsoil water or water in a state of running, such as the rivers, nalas, springs, streams, and the like, which is other than the irrigation work and is the property of the government.
It doesn't contain borewell.
No, that is a. It is also cannot be brought within the definition of deposit of water at a fixed place. And also this is not water, it is a subsoil water. This is not also that. You just, Mr. Bajoli, you just take an instruction.
Yes.
We are fixing the matter on 24th of August 2023. Right?
August.
Let the matter be listed on 24th of August 2023. Meanwhile, Mr. P.K. Muduri, Additional Government Advocate, 51 shall take instruction how the fees for use of the groundwater has been imposed on the petitioner, or how the penalty, penal interest has been imposed for purported non-payment of the fee. Mr. S.P. Mishral and his senior counsel, listed by Mr. L.K. Maharana
Maharana.
has submitted that at no point of time the petitioner was defaulted in payment of any demand raised by the government.
But if your lordship kindly see one document, my lord, pay 159 pages. Page 159. I have given a chart, my lord. Just before the remark, paid by us for normal rate. The charge bill raised from 2010. Kindly look at the last portion.
Yes.
Page 161. Even May 2022, they have charged us. But 2017, the agreement has been executed, surface water I am using. Going on compounding the matter, I am paying the regular bill. So no coercive action should be taken.
Already you also take instruction over that issue.
Yes.
And whatever I gather from the submission of Mr. Mishra, that he will be happy if you do not just impose the penal interest. Right? Take that interest also specifically, whether that is possible or not in the given circumstances. All right.
Item 7.
Grateful.
Yes.
Please, Manoj. This is the matter.
Yes, I am minute the MLA has been made a party. So I pray minute 2 seats pass over.
My lord, it was.
Why the MLA should
not,
make the
it is
party?
not. This
No.
rate is not maintainable, man.
Absolutely, minute
I will just maybe.
It is up to you, Mr.
My lord,
No, only it's up to you.
disposal.
You cannot hold back the other council because you have a matter in other.
My lord, only
That will not permit.
it was only on a limited issue, my lord.
Will not permit that.
My
Mr.
lord,
Acharya. Is
order
that-
number 1 may kindly be seen.
No. Yes.
Order number 1 may be seen. My lord have directed to give the status of that appeal, my lord. In
Yes.
this case, there is a judicial order passed by the assigned bench to list the matter. My lord, prayer is only to list the matter and hear it as quickly as possible. That is page 34 of the writ petition,
Yes.
my lord. And there is a judicial order at page 160 of the assigned bench. Rest is for the registry, my lord. Nothing, no parties, and this is not the PIL is in file even despite this judicial order, right? The intention is no. Why
Intention is
the intention is not
intention
of publicity judgment. The intention I take strong exception to my learning.
Let us hear also Mr. Palit. Yes.
Yes. In 2013,
This is your prayer. On the rate petition, what is the prayer?
I'm coming to the prayer. Prayer is exactly in line with the direction of the Honorable Supreme Court in that consumer Center for Public Interest Litigation.
Mr. Palit, just as only on last Thursday, we have constituted a committed bench to hear all these matters. Expectedly within the time frame, these matters will be.
Your Lordship has committed.
Already a special bench has been created. All right, on last Thursday. So I think this will serve the purpose of this writ petition.
This is before the Honorable single bench.
All right, single bench.
Division bench, probably if your Lordship has special bench, division bench. Then, my lord, that would probably deal with offences of the nature of.
I understand. There is also single bench has been created.
Your Lordship, with that observation that
all right.
matter may be disposed of. That would take care of the.
Because this is the limited prayer, without entering into all the dispute, let this proceeding be started, which is stuck up in the High Court.
I am also not on the merits.
Now I think we have been paid matters. I am rather.
What I am telling you.
For disposal.
If you are keen for disposal, I am telling you, these matters have been categorized specially.
I know that.
A committed bench has been, a dedicated bench has been created. They will expedite matter on the first track.
Mallards.
That's all.
It was also listed before the
Mallards.
dedicated bench.
Ah.
Not that that time also following that assembly government judgment. Those benches have been created. It was hard by case process. He is a stranger, Mila. It's a criminal appeal.
Justice Sahu was not part of that, the criminal appeal also, because it was Justice Vishwajit Mohanty. After that, the bench was not created.
Created, I think, Justice B.P. Rao. It was listed before.
That is in the single bench, Mr. Raut, before the single bench. All right, we will go there. We have already, no, just here, we have segregated all the matters. A special list will be published.
That's correct.
And that
there
is-
is no problem on my part.
Just
but my
one
question is-
moment.
Let me.
No. This matter will not be taken out of turn. This will come on in the same category.
That's all.
That is what. That is what I cannot upgrade a matter without looking in the records.
It's a different bench altogether.
This is not our job in a public interest litigation.
We are also not on
Because
the,
of the public interest litigation,
Mallards.
this matters requires early disposal,
Yes.
not getting disposed of.
Mallards.
And public has a very big, this tweaked perception about the judicial institution. They are hand in glove with the politicians.
Have been trying hard to dispose of. We have been working last 7-8 months.
Yes.
The bench is overoccupied. They are trying their best.
True.
So I am also very keen for disposal.
All right.
That they give fair, that is.
All right.
Paper book, the paper book is being prepared by the registry of the High Court. In a neither
The particular difficulties in a particular case raised before the learned bench, and they will take a decision. We cannot pass any order on those matters. All right.
I am not on a particular case, man. I am on the general direction.
No, your prayer, you have stated a particular
I have-
case, that
I have-
is why the anxiety.
Mallards.
But he need not have any anxiety because similar types of
If
cases
your
will be
lordship has
listed.
made arrangements, Mallards, if your lordships have already made and constituted a special bench with that observation, Mallards, the petition
That is
will
what
be
I am
disposed.
doing. But we cannot observe.
Not for this case, all similar
No,
nature of
also,
cases.
yes, I get the point, Mallards. I get the point.
bench should be constituted immediately and the matter should be taken off.
That is already constituted. We are publishing the special list for the different.
Lordship will be publishing a special list.
Yes.
That depends upon his lordship's workload and board.
Yes.
It can't, the division bench can say that you dispose it off.
No. This special.
This is not 1:1, Mallards. This is not a 1:1 litigation.
All right, Mr. Pandit, we got it. Point.
Administratively, the prayer has been made, incident.
Election case against this MLA. This MLA cutter.
We are not concerned about
I'm
the
not
particular
arguing
case.
that case.
Mr. Acharya, just wait. We are not concerned with any particular case. We are the.
Publicity, political storm.
Please,
Mr. Acharya, don't you know PILs are misutilized for this purpose? All of us know.
My lord, in the order, my lord,
Mr. Acharya also must
I
have
pray, my lord,
several
the order
prayers. It's not.
is 160 of the single judge judicial order may also be noted.
We have seen.
Just to follow.
The order was very categorical. List this appeal.
Supreme Court in Rahul Gandhi case.
List this appeal on 22nd February for hearing. This was the order. In the meantime, registry is directed to prepare paper books and serve upon the concerned counsels appearing for the respective parties.
Mr. Pandit, that is the usual order in all cases.
Mallards.
So why should this be taken out of?
No,
turn?
not out of turn, but
No, we are this, according to the Supreme Court guidelines, this special.
my anxiety is let it not languish. Let it not languish by normal.
That is why the special benches are created and category wise special
Mallards.
list will be published.
Mallards.
So you'll be knowing this is that category matters. So it will be listed before who is the dedicated bench of the learned single judge
Mallards.
and the division bench. They will take up the matter. And
Mallards.
Mr. Acharya is right because these judges are not free only to take these matters. Their board is alarmingly congested. That also we are category. Heard Mr. Shubhi Pali, learned senior counsel, who is assisting you?
A Pradhan.
People may say Pradhan counsel appearing for the petitioner. This writ petition in the nature of public interest litigation has been filed to expedite the matter relating to the politicians pending in this High Court. Mr. J.P. Patnaik and additional government advocate at the threshold raised the objection as regards the maintainability of the public interest litigation. As in the prayer, only one criminal appeal has been mentioned. For that purpose, according to Mr. Patnaik, the public interest litigation cannot be used as the instrument. So, be that as it may, this High Court has already constituted a special bench for hearing the special category of matters relating to the politician. Criminal matters relating to the politicians. With hope that within 6 months, every matter will be first track for disposal. In view of the above, we don't find any necessity of passing any further direction in this matter. Accordingly, this appeal, this petition stands disposed of.
Item number 8.
Please, your Lord.
Yes.
Very embarrassing situations has happened in the consumer forum. Your Lordship, kindly visualize a situation. The Secretary Law and Company Affairs of the central government interferes in the assignment, listing of the matters of the Honorable High Court because it's processing all matters. What is
Honorable
the
High Court?
My Lord, I'm just giving an instance. Here it is a case.
No, just don't mention the Honorable High Court. We know
Because,
how
my Lord,
matters are listed.
Because, my Lord, I am just, my Lord,
Don't give these parallels. I understand where is his grievance lies.
My Lord. But in fact, a similar case, a situation happened in case of income tax appellate tribunal. But the Bar Association of the Income Tax Appellate Tribunal, they filed a petition before because such a letter had come.
For the central government here?
No, my Lord, here state government is concerned.
No. Who is anybody is appearing for the central government?
Central government is not a concern here, we're not a party. But here what has happened, my Lord, the ex-president, he retired on 2/7/2023.
Who is appearing? Mr. Mudali, are you appearing? Yes. Why you are not appointing? And according to Mr. Mohanty, that you are also not allowing this commission function.
State Consumer Commission, my Lord.
No, it is functioning.
Not functioning. Because how the secretary will detect, do this thing, that thing.
We are giving you 30 days time. In the meantime, you appoint the chairman. 30 days time is a longer period because your duty is to immediately someone demits office, get yourself prepared knowing that he's debiting office on such and such date. No, Mr. Mohanty, don't show the 2 fingers. 1 finger is sufficient for this.
My Lord, it is in the process, 2 months time.
No, sorry.
You submit to the court instead of.
No.
Or during such time, my Lord.
You show this 2 fingers as a victory sign to Mr. Mohanty that he has brought the matter before us. We are passing the order. You should be happy because he is pointing out to the depths of your officers.
My Lord, sometime secretary also may be a party in the consumer matter. How can he detect in contravention with provisions of law?
Department detect.
But my Lord,
these are unrecorded matter. We will not do anything.
But the petition number 1 being the senior most, my Lord, senior most.
Secretary is a judicial officer.
No. I am talking of the civil supplies.
Civil supplies. He is the nodal secretary of the nodal department.
Yes. He has issued the direction for constitution of bench.
That is in process. They will
That is all right, Lord.
High Court.
But we are concerned, Lord, till such time, the president.
Mr. P.K. Mohanty, senior.
But Lord, one thing, my praise. During such time, Lordship kindly state that 5, 7, 11, because the petition number 1 is the senior most member, automatically deemed to the president. That is acting president. That is as per law. That Lordship kindly say.
No, during that period already, this is what.
During that period, let him cooperate.
According to the law,
my Lord, now it has become not a private, again private interest litigation.
No. Just I'm
not private.
My Lord. Here, how we that in the meantime, within 30 days, that the commission will function in accordance with the law.
Yes,
your Lordship, may kindly see the averments made in paragraph 7.
We are not taking cognizance of any averments. Is passing a direction on the face of the The basic facts they have laid before us that the chairperson is demanded, no new chairperson has been appointed.
Well, may I suggest one thing? Your Lordship may call this matter on 23rd.
No.
Your Lordship may grant me time.
No.
Till-
Sorry, you will not grant.
As to
This
the
is not the
steps
time.
which has been taken and as to the steps taken for appointment of the regular president, that part I will obtain instruction. Your Lordship may grant me time till 22nd, Tuesday.
All right.
But till then, your Lordship kindly grant stay of 5, 7 and 11.
No.
So that,
Already.
but Lordship kindly have a look at Rule 8.
Government advocate, let the matter be listed on 22nd of August 2023. Stop. Mr. Muduli in the meanwhile take instruction why the chairperson of the State Consumers Commission has not. President State Consumer Commission has not been appointed in the wake of the demeaning office by the former president of the State Commission.
This has been,
Mohanty Land Council has submitted that the cases are being listed at the dictate of the opposite party number 1. Though according to the provisions of the Consumers Protection Act, the senior most member is supposed to act as the ensures.
As per Rule 8.
As per Rule 8.
Office sitting president.
Rule 8 of the state Consumers Protection Rules.
Yes, my Lord. Odisha Consumer Protection Rules
Just give the
2020.
book. Yes.
Lordship.
This is the common rules.
We have quoted also in page 6, we have quoted that. In the
As per the Rule 8.
Rule 8
of the Orissa Consumers Protection Rules 2020. In the event of the casual vacancy in the office of the president in the State Commission, the senior most member shall be deemed to be.
My Lord Justice Ratho may kindly.
Right. Stop. So without looking into these technicalities, we would observe that till the next order, the senior most member of the State Consumer, I am not a petitioner, shall act as the acting president of the state, officiating president of the State Consumers Commission. Stop. A copy of this order is supplied to Mr. P.K. Mudali and a regional government advocate for transmission to the company.
that will
This is the rule.
expedite matters.
No, this is the rule. How can you avoid this? One rule is very express. How can you avoid?
But this is not a PIL.
For this,
Not a PL. All the members have come up before Lordship.
All right.
All the members have come up before Lordship.
Item 9.
7, and that is really disturbing.
That
What
is
are the allegations? What is the law? You follow that.
That is one part.
We are
That I
not
will
going
follow.
into the allegations.
But this should not have been there in paragraph 7 in writing.
In writing.
Yes,
Oh, that-
but you can see paragraph 7.
There is various reasons are there behind this.
No,
Because
all right. It's just you come. This
if Pandora box is open, my Lord, your Lordship will know
For
everything.
the timing, this will be the arrangement.
Oblige, deep oblige.
All right. The written instruction before us to demonstrate how the police has been acting to recover the victim at the earliest occasion. Stop. Let the matter be listed again on 31st August
H.S. Pandam.
2023. Mr. H.S.
H.S.
Pandam
Pandam, amongst
has appeared for the petitioner. All right, 31st again. In the meanwhile, it is expected that police shall recover the minor. Stop. Minor victim.
Item number 10.
My lord, in this case, I have also removed all the defects, my lord, yesterday. For so far, item number 11, I also removed the defect today. So, my lord, let it come in a fresh admission next week or any other to convenient to my lord.
All
I have That defect which has been pointed out by SR, I already
At
removed.
the request of Mr. Aviram Swen and counsel appearing for the appellant, let the matter be listed of 1st of September. The admission Friday, then 18th of September again.
18th.
Stop. The other matter also same. only.
No, my lord, the substitution is also there, my lord. If he, my lord, say please to list it earlier, then.
It cannot be because I was asking for a shorter date, but it's not possible.
My lord, oblige.
All the matters Mr. Swain is appearing. And I think it can also send the order.
You are appearing for the appellant as well as the respondent.
No, my lord, say, but after substitution, they gave the separate worker, so that's why it is the bottom. That's my. Sorry for.
Up to 11, you are appearing in all the matters.
All the matters. My lord, it is also with 270 also above, but it is also in the separately.
11 and any
11 also.
11 is also.
Also in the same.
Up to 11.
Arising out of one order, my lord.
All right. Same date.
Same date judgment, everything same.
All right.
Were some matters listed yesterday or that was different?
No,
that was different. All right.
All
no,
right.
my oblige.
Item number 12.
Oblige.
May I please, your lordship? In this matter, your lordship, today I'm filing the IA for substitution.
Have you filed this petition for substitution?
I'm filing today, your lordship.
It is not done. File it before the
Why I'm saying so, your lordship, is because the fact is only respondent number 1 has died during the pendency of the writ appeal. All the other respondents who have died, they have died during the writ petition prior to the review of the order. They will not be substituted. Now I've collected the death certificates, your lordship, including your lordship.
So there should be 2 petitions.
2 petitions are there, your lordship.
One for substitution and then for the impleadment.
For the I've taken for addition. I've filed an IA for taking additional grounds, your lordship. The 2 IAs are there, your lordship.
So file it before the registry.
I will file, your lordship.
All right.
It will be on Monday, your lordship.
No, on 31st will come. You filed it today.
My lordship.
Let the matter be listed on the 1st of August 2023. Mr. J. Biswal and the council appearing for the appellant has submitted that the appellant are going to file the substitution petition for bringing on record of the legal representative of respondents number 1 to 4 and 7.
Respondent number 1, your lordship. I beg pardon. For substitution for respondent number 1 and for other respondents, there is another IA, your lordship.
All right. 1. And he has also, Mr. Visual has also stated that he may file a separate application for bringing the persons who respondents number 2, 3, 4, and 7.
7 is not died, your lordship. 7 is still alive.
You stated on earlier occasion.
Because the counsel for the respondent who was appearing, he has stated that respondent number 7 has died.
Actually, it is not died. For the respondents who have died during the case of the petition, but they are and their legal years were not substituted in that proceeding. All right. Anyone is appearing for this? No. All right.
Much obliged.
You are not there.
The Central Cooperative Bank, your lordship, the appellant. All other the.
All right. Next item.
Item 13.
May I please, your lordships? Lord, this defects has been pointed out for the first time by your lordship's order dated 31/7/2023. Entire defects practically have been complied. Only the difficulty I am finding, my lord, because technically I have to upload the receipts, which is 5D receipt showing the service to learned advocate general. And other defects, 6B is the provision of law, and other defects put 7 and 9. But practically, I have complied the entire defects which has been pointed out by your lordship's order dated 31st July. But the only difficulty I am finding to upload it, I request your lordships to grant a week time so that I can clear all the defects, my lord.
All right. At the request of Mr. Manoranjan Das Mahapatra, learned appellant who is appearing in person, let the matter be listed on 31st of August 2023 Meanwhile, the remaining defects be removed. All
I
right.
am deeply obliged, my lord.
Item 14.
But item 14 actually, I brought it to your lordship notice that there are actually no delay in filing the writ appeal. But since the office note indicates there is 26 days delay, I have filed an application explaining the delay itself, that it's not there.
21 days delay, of course.
But if your lordship looks at the order was passed on 22/3/2000.
Opposing to the delay, 21 days delay.
No, I have absolutely no opposition, but there are some private respondents, I think.
Oh.
So I feel there is no delay. That's the reason why I want to explain. Because I obtained this certified copy, I applied on 28/2/23. Let me
Yes.
kindly visualize. 22 February 23, the order was passed. 28, the application was filed. It was made available on 29/3/23. So that period of 1 month has to be added.
Office shows that certified copy period is 3 days. That's a mistake.
Oh, that's a mistake.
Where is your certified
That is
copy?
what exactly I wanted to bring your lordship notice.
Where is your certified copy?
3 days. Office of 3 days.
वो सर्टिफिकेट को पछपट्टा जेरॉक्स करना है
हाँ मैंने
पछपट्टा जेरॉक्स
certificate file doesn't it? File that in.
the back side of this certificate copy include order is not
Oh, this is that case where there is the dates are not visible there. That is
Yes,
that case.
Yes,
Right,
yes,
right.
yes. Sir.
Date of application is 11/2/2020. Am I correct?
No, it can't be 11/2 because the order is
It is actually
it has been smudged.
29/3/23. Then 17/4 it was filed.
What is this 11/2? Oh, that is 23.
Right, right.
Date of notification. Why are these marks there? So it has to be 2.
It is 22/2/2020.
Is it
There is
2?
a date of the order.
No, because from the smudging it appears 22/3. That is why he's given you 3 days only. That is the problem.
Yes, that is true.
Smudged. So you've taken it as marks.
But your lordship may hear it on merit. If your lordship finds that I have some substantial question.
No, because no substantial question is there because the private respondents are there. So we have to issue notice in their
Look,
absence that can be done. It
I'll
cannot
take
be
notice.
done. That is why you're pointing out. But Mr. SP National and Council, what is his good name?
Omkar Panda.
Stated by Mr. Omkar Panda, Council, appearing for the applicant in I number 4824. I number 4824. There is an application for condoning the delay of 21 days in preferring the intercourt appeal. From the order dated 22/2/2023, delivered in WPC number 8711 of 2012 by the learned single judge. So issue notice as to why the aforementioned delay shall not be condoned or any other order or orders shall not be passed. Notice is made returnable on 27th of September 2023. Since Mr. D.K. Mohanty, learned additional government advocate, appears and waives notice for the respondent number 2. No
One,
formal
two.
note.
1 and 2.
One is a private
Oh,
respondent.
I'm sorry, I'm very sorry. 2.
No formal notice is called for. The applicant shall take steps for service of notice on respondent number 1, 3 and 4 by respect posted 18 within 3 working days from today. Take within steps by 3 working days from
Yes,
today. Yes, next.
Item 15.
But in this case, you know, which petitioner, and they filed, caveat will serve the copy, but will file the IA for delay. Says delay of 65 days, madam. Order of honorable single judge will challenge the return.
So you have not filed the application for condoning delay?
Already filed. And it is the IA number,
Yes, I number 4110 of
Yes, yes.
2023. No notice has been issued as.
My lord, this read, I am for the respondent, my lord.
as respondent is appearing, will serve the copy, man.
Have you removed the defects from the appeal?
I don't think so, my lord, it was defective. Mr. Gupta is appearing with me.
Whatever, by the order, specific order, you are asked to remove the defect on 11th of May. Today we are in the month of August.
The last chance may be given. Mr. Gupta is not.
Mr. Padhi, if you are appearing for the appellant, how can you say Mr. Bhukta is supposed to be assisting you?
He is assisting me, but he is.
It's a request of Mr. P.K.
Where is-
Pari.
Some problem, that's why.
Deputy Solicitor General of India. Let the matter be listed on 31st of August 2023. Meanwhile, the defects as identified by the registry shall be removed.
One
If if it is found on the next date, the defects are not removed. The defects have not been removed by the appellant. We may pass an order for non-prosecution. Stop. You have a filed Bhagaratnama?
Yes, I am a cavator, my lord. I have cavator.
File a caveat application.
Also for the respondent.
Yes, after listing my this case, my name reflected. That's why I am appearing before the honorable court.
He must have filed the Bhagaratna caveat that may be attached to this record.
Your good name is?
Sapan Kumar Pal.
Mr. Sapan Kumar Pal and counsel has appeared for the caveat.
Mr. Padhi, rupees 10 you have to pay legal assistance fee or something. Just check and do it.
I leave to my lord.
No, it is not. We are not supposed to file. The
My lord-
CGC will file.
My lord, a respondent is a retired person, 75 years old, my lord.
That is why you have fixed the matter on 31st of August.
Yes.
Earliest possible date we are providing to you.
Yes, yes, my lord. Yes, my lord.
Item number 16.
Obliged.
My lord, item number 4, passover matter.
Wait.
Which matter is mentioning now? No, this matter will be after the admission matters is over, then call. Yes.
May I please?
16, sir.
In item 16, two interim applications are there. One for dispensing with and second for condonation of delay, madam. So for as condonation of delays, there is 174 days. Application. Yes. please.
This is an application.
My learned friend is appearing if he appears.
In the read petition, I was,
And I can serve him
Are
a
you
copy.
appearing for the writ petitioner respondent?
yes,
Have you received any copy? Then you give this.
I'll serve.
Do you have any objection if you dispense with the filing of the certified copy?
no.
All right. What is your good name?
Lakshmi Narayan Rohit Singh. Lakshmi Narayan Rohit Singh.
Ellen Watson.
All right. The IA. 3973 of 2023. This is an application by the appellant for dispensing with the filing of the certified copies of the order dated 15/12/2022 passed in WPC number 8131/2022, which has been challenged in the intercourt appeal. So it has been stated that as the appeal was supposed to file at an early date to avoid any collateral damage, any avoid any legal complication, the certified copy could not be obtained. So, however, Mr. MK Kantiya, an additional government advocate, has indicated that a downloaded copy of the impugned order has been furnished with the memorandum of appeal. Stop. Mr. Sachin sir, when counsel has appeared on information for the writ petition and respondent.
Well, in fact, that is not downloaded, that is Xerox copy.
Xerox copy,
My-
all right, Xerox copy, right? Photocopy of this. We do not find any impediment to dispense with the filing of the certified copy of the order dated 15/12/2022. But such certified copy shall be filed within a period of 30 days from today.
My lord.
Stop. The filing of the certified copy of the impugned order dated 15/12/2022 dispense with subject to the condition as may follow. In the result, this stands disposed of. Now, what is the writ appeal? Come to the
Petitioner has filed the writ petition.
Well, this case will be squarely covered by my lord's judgment. So that has not been uploaded. So your lordship may fix it a certain date that can be after that regarding that rehabilitation matter.
Already fix it on 23rd.
Any date thereafter, my lord, because that order to be uploaded, that
Yes.
order has not been uploaded. So
Already. When it can be the 20. We do it on 30th of August.
My lord.
This is the matter again on 30th of August 2020.
If they will show me the copy of limitation petition and writ appeal,
Also
I will
give
file
it
my appeal.
because
Yes, in course of the I will sir.
Publish.
Item 17.
17 also that rehabilitation matter, there is a limitation and a dispensing with petition. Both the matters can be fixed to that date.
already
So that those matters can be covered by my lord's judgment.
already.
Item 18.
May I please, my lords. Lord's Honorable Single Judge refused to entertain the writ petition on the ground, of existence of alternative remedy, Lord. Lord, the impugned order is passed by the Provident Fund authorities, my lord. Lord, and my bank account of the petitioner, my lord, has been attached, my lord. Lord, this, my submission is, my lord, this order is totally without jurisdiction. My lord, this section 16, 1B of the Provident Fund Employees Act, Provident Fund and Miscellaneous Provisions Act, my lord, 1952, my lord, provides, my lord, I am reading out, the act shall not apply to any other establishment belonging to or under the control of the central government or the state government whose employees are entitled to the benefit of contributory provident fund or old age pension in accordance with any scheme or rule framed by the central government or the state government governing such benefit, my lord. This is a, my lord, the institution, my lord, affiliated and by the government of Orissa. Your lordship may kindly see page 44. Page 44 of the brief. Lord, it is notified for all information of all concerned. On
No,
funds.
you just read again Rule 416. Give them this Employees Provident Fund Miscellaneous Act. You are referring to a page?
Lord, page 40. Lord, page 44 of the brief, my lord. Page 44, my lord, permanent affiliation. Thereafter, my lord, page 45, my lord, also the same, it has been granted renewal permanent affiliation. My lord, thereafter, my lord, page 46, my lord, permanent recognition, my lord. Permanent recognition, page 46. my lord, page 47, 48 also, my lord, speaks about the permanent, my lord, appeal, recognition, my lord. And my lord, this section 16 clearly says, my lord, if it is an educational institution, my lord, the provisions of this act will not be applicable. 16(1)(b).
But your organization doesn't come under these two categories of establishment.
My lord, I am coming with B, my lord, any other establishment belonging to or under the control of the central government or state government, whose employees are entitled to the benefit of contributory provident fund, my lord. I am under the control of the state government.
How you say that because of the permanent affiliation?
Because of permanent affiliation and recognition,
This is
my
not
lord.
the meaning of the control. It is called the financial control, and there also.
My lord, that control word has been interpreted, my lord.
No, just not by your interpretation. This is also coterminous with that they are getting the benefits of the central government.
Look, central government or state government.
That is whether these employees of that institution are getting the benefit of the central government or the state government.
State government, my lord. State government will provide them pension, my lord, after their retirement, my lord. As per the educational institutions, my lord. These
are the aided institution.
My lord.
This institution is an aided institution.
This is a aided institution.
That is why I am asking you.
Under the control, my lord. Aided institution will come under the, my lord, this category of control, under whose control, my lord. The control, under the control of the state government.
Appearing for the Provident Fund Commission have a standing council here? No.
No. They have a panel, my lord. My lord, now what they are doing, my lord, they have attached all my bank accounts, my lord. That is why I am in trouble. And my lord, this the order is without jurisdiction, my lord, the alternative remedy will not be a bar, my lord. It has been decided by your lordships. And
no, these are merit. Now you cannot decide it.
No, my lord. Your lordship may issue notice and examine the matter.
Yes. Heard Mr. Soma Sagan. You are Mr. Soma
Darshan Mahanti. Yes, ma'am.
Darshan Mahanti, like the document. By means of this intercourt appeal, the appellant has challenged the order dated 12th July 2023, passed in WPC number 21309 of 2023 by the learned single judge. According to Mr. Mohanty, that the appellant, being the writ petitioner, had challenged the authority of the respondent number 1 and 2 to issue the impugned demand notice and subsequent order freezing the bank account of the appellant. Mr. Mohanty has referred to section 16 within bracket 1 small b of the Employees Provident Funds and Miscellaneous Provisions Act 1952, which made a clear exemption by providing that the said act shall not apply to the establishments belonging to or under the control of the central government or a state government, and whose employees are entitled to the benefits of contributory provident fund or old age pension in accordance with any scheme or rule framed by the central government or the state government governing such benefits. Stop. Mr. Mohanty has categorically stated the employees of the appellant are getting the pension from the Government of Orissa, and as such, invoking the jurisdiction under the EPF and MP Act 1952 is wholly illegal and without jurisdiction. In such cases, according to the appellant, the jurisdiction under Article 226 is available, even if there is any alternative remedy prescribed by the statute. Admit to be heard in merit, issue notice returnable on 27th of September 2023. Steps on the respondent shall be taken by the appellant within 3 working days from the date of instruction.
Lordship may say no coercive action, my lord. They have no coercive action.
All right.
I filed an application, my lord. I have filed.
I number 4291 of 2023. Stop. Lord Mr. Subhas is saying, by means of this application, the applicant is paid for stay, paid for appropriate order. Mr. Subhas is saying, counsel is appeared for the applicant and stated that unless a interim protection is granted to the applicant may face serious jeopardy and the applicant will not be in a position to run the institute and pay the salaries and wages of the employees. But we have prima facie examined the nature of the challenge. So, having examined thus, we proceeded to pass an interim order in the following column. Till the next page, there shall be no coercive action against the appellant. Let's stop. Issue notice, returnable on the same date. The applicant also shall take steps of service of notice on the opposite parties within 3 working days by registered post.
Obliged.
Yes, Paul.
Item 19.
My lord, a second copy of the writ application has been filed today. Inadvertently, it was not filed earlier.
File it, we are fixing that.
Already filed, my.
All right. It is 19 now?
19.
It has been stated by Mr. K.K. Raut. You are Mr. Raut.
My lord. No, junior. S.K. Raut. S.K. Raut.
Sorry. Mr. S.K. Raut, on counsel appearing for the petition, has submitted that the second copy of the petition has been filed today. Let the matter be listed again on 31st of August 2023 for consideration. All right. It will come again on 31st of August.
No, obliged.
Item 20.
It was possible material followed by item.
That passed over matter, item number 4.
My lords, I am appearing for the appellant in item 4, my lords. I am appearing through VC, my lords. Your lordships may permit. I am audible and visible, my lords.
My lord, VC for the caveator, my lords. Copy has not been served to me.
My lord. On behalf of Mr. Sangnaya, caveator.
We are serving a copy, my lords, but what has happened, my lords, I should bring it to my lords. This is an order passed by the learned single judge, whereby, my lords, the learned single judge has directed that the final rolls to be the electoral rolls of the particular election, which is supposed to be conducted by a private body, is to be finalized by the ADM. This is a purely private body of District Truck Owners Association. It comprises of members of the truck owners. And therefore, there is no role of any external body to interfere in the election process. And despite earlier orders of the learned single judge on several occasions in this regard, that in the association, in a private association, there is no role whatsoever because it's not amenable to the writ jurisdiction. The only role that a state has in this kind of matters, my lords, is of a night watchman. That is of to provide law and order. to ensure that the election takes place in a free and fair manner. And my lords knows that the preparation of electoral rolls is intrinsic to the election process. So the electoral rolls are prepared. My lords may have a look at the impugned order, my lords, for a moment. The relevant part, my lords, is at page 24, the operative part. Para 8, my lords, of the impugned order.
Yes.
My lord has it. Considering the above facts and submission made and without going to the merits of the case, this court disposes of the writ petition directing the opposite party number 6 to prepare the electoral roll and place it forthwith before the opposite party number 4, ADM cum additional register of societies, Kyonzer, who shall finalize the electoral roll by end of this month, that is 31st July 2023. Thereafter, my lords, he has made a publication for the final elections to take place. My lords, as a result, what has happened, my lords, because of the interference of the ADM, a substantial sections of the voters who are members of the association have been excluded. Therefore, I pray, my lords,
But,
that
whether do you admit this fact that this additional district magistrate also the additional register of societies? Do you admit this fact?
My lords,
That the ADM is also the additional registrar of societies.
my lords, he is operating, yes, my lords.
So that you cannot exclude him because it is the society, registered society, the registrar of the society or the delegate of the register of the societies in various districts. They enjoy the similar powers of the register of societies and they can look after regarding the management of the society, including the conducting the election.
My lords,
So you cannot say that that ADM who is in joint charge of the ADM and the additional register of the cooperative society is a completely stranger in the situation.
My lords, I bow down to what has fallen from your lordships. Lordships, in this regard, earlier already in the previous occasion when the elections had not taken place in the last term, and this question had come up before your lordships, before a single judge of this honorable court, and this was considered. And by looking at the bylaws, this court has held that therefore the ADM had no role to interfere in the election process. He can facilitate the conduct of the elections, but to prepare the electoral rolls is overstepping the boundaries fixed under law, my lords.
What do you mean by facilitate? No, what do you mean by facilitate? So that election is conducted in free and fair manner?
Free and fair manner, my lords.
If you do that, even it is not expressly provided anywhere, that he can also say that you do this in a particular manner.
My lords, I'll take your lordships to 2 orders, my lords, earlier, passed by this honorable court.
Yes.
One is when an advisory board was directed to be constituted for conduct of the elections. The same learned single judge in an earlier matter has said that composition of the advisory board is not permissible. Therefore, the advisory board constitution by the ADM had to be paused. That is that order dated 1/8/2020. See this at page 40 of the writ petition.
What is your grievance? Tell us.
Well, grievance is that, my lords, in the preparation of electoral rolls, the ADM cannot have any role in the preparation of electoral rolls. That is
what kind of rule you are alleging? If he says someone to prepare the electoral rolls, is it an interference?
Yes, my lord, because electoral rolls is to be, my lords, can he step into a private body, private association?
No, in the capacity of this additional register of the cooperative society, he can enter.
My lords, I did my research, but I could not find any relevant provision by virtue of which he could step in as the ARCA.
Right. Give the Cooperative Society, Orissa Cooperative Societies Act. Mr. Muduli, what is the role of the registrar? Because the Model Cooperative Society Act that is based on the Mumbai Act, there's section 92, this gives the registrar is to be in charge whether the free and fair poll is conducted in the societies. When there is a dispute raised, he exercises his authority also.
My lords, this issue has been discussed, analyzed threadbare by the single judge when he had the occasion to deal with it. The same single judge, my lords, in another writ petition, a batch of writ petitions, he was dealing with the same issue, my lords. And he has threadbare examined the memorandum of the society. He has looked at what is the scope of interference, and he has come to the conclusion that there was no occasion for the ARCS or the ADM to interfere in this matter, my lords, in the election process. Your lordships may permit, I will place that relevant order, my lords. I have annexed that order.
Not the Cooperative Societies Act. The State Societies Registration Rules. It is not a cooperative society. It is not a cooperative society, I believe.
No, my lords. This is a association.
Society only.
It's a registered society, my lords. My lords, in this case, the secretary was to prepare the list and the final list was to be approved by the ADM. That was the order that was passed, my lords. What my learned friend is saying is completely wrong. The secretary was preparing the list of the electoral roll. Then the ADM was to finalize the voter list. So therefore,
What is the role of the ADM, my lords? Why should he step in here?
My lords, because we had alleged some inconsistencies against the secretary. We had said that he is trying to because he was the outgoing secretary and he did not have the power. The way he was trying to interfere with the democratic process of the election. He was not letting the election to be held and not allowing anybody to enter the electoral roll who were already members of the society. That is the reason why, my lords, we had filed the writ petition.
Electoral roll has been published already?
Yes, my lords, it has been published already on July 31st.
And objections are invited?
Yes, my lords, nothing remains now. Everything has been done. It's finalized now. The election is supposed to be held only, my lords.
All right.
My lords, he may show which is the provision by virtue of which the ARCS can step in, my lords, in a private association.
No, he says differently. He says that it is the secretary who is.
No, my lords, that is absolutely wrong. My lords must see his prayer in this writ application.
See the order, my lords.
Where is those record that this ADM is interfering?
My lords, that is, my lords. My lords may see this is order dated judgment of this Honorable Court of 1/8/2023, starting at page 40 to 57.
Judgment dated
1/8/2023. That is starting at page 40, my lords.
This is a completely, because there is no reference that ADM was in additional charge of these additional register of the societies.
My lords, that starts at page 42. In that writ petition, the members of the general body had directed to enable the members of the advisory body to take over the office of the District Truck Owners Association and initiate necessary action for election of the next governing body. It was the same process that was sought to be initiated at the behest of the ADM. So the minutes of the ADM's meetings were quashed by this Honorable Court. Again, what was not permitted by this Honorable Court subsequently, in an innocuous manner, that has been directed, my lords. Court, while not directing that they're entering into the merits, while the prayer was only that to provide law and order situation, to avoid a law and order situation, the writ petition was entertained. Eventually, this amounted to an interference in the election process.
You come to the judgment that you have referred.
My lords.
In paragraph F, page 9, internal page 9 of the said judgment. It says the term of the governing body has already expired. The same case is here. Yes. And the district administration has convened a meeting and a decision was taken for conducting election such and such time. More than 9 months have been elapsed despite the direction of this court to the ADM to take appropriate steps for conducting the election of the association. What you are submitting, this court also directed the additional district magistrate to take steps for conducting election.
My lords is reading out from which portion I could not follow, my lords.
No, this is in judgment.
The impugned order, my lords?
All right, yes. All right. Thereafter, what happened?
My lords, looking at the impugned order?
Yeah, I'm reading impugned order, but this is the submission part.
Yes, my lords. My lords, we have no grievance if the election process is initiated. But it has to exclude the role of any external agency. The private body has to organize it itself.
Mr. Mahapatra, in that judgment, operative portion is at paragraph 19 and 20.
My lords.
Paragraph 19 and 20 of the judgment.
Yes, my lords.
So you are not aggrieved by that?
We are not aggrieved by that, my lords. That is the order passed by a single judge in another writ petition.
Yes.
Where they stopped the interference of the ADM.
No. Why are you showing us this order?
Because that order is inconsistency with the law, my lords. That says that the ADM cannot interfere.
Where does it say?
My lords may see, my lords. I'll take your lordships to page 55, the operative part, page 55.
55. Page 56.
Yes, my lords. In fact, my lords, if your lordships may have from page 54.
56.
Page 54 will have a brief background as what has transpired, then they have come to the conclusion. Lordships may have a look, lordship will understand the perspective in which the court has passed that order, my lords. Page 54, my lords. Para 15, my lords, may have, my lords. The lordships have it.
Yes, it says names of the eligible voters list is yet to be published.
Yes, my lords. Thereafter, in conformity with the aforesaid decision of the committee, the association by notice dated such and such published the provisional voters list and invited objections from the members to be filed between 21 June to 27 June with the requisite papers for the purpose of inclusion of the eligible voters. In view of the development, the election process has commenced to constitute the succeeding governing body of the association. Insofar as the advisory body is concerned, clause 4C of the Memorandum of Society under the Act provides the constitution and function of the advisory body which are extracted herein below.
That is all right. What had
My lords,
the ADM
my lords,
directed by 25/8/2022, which has been set aside?
Well, they had stepped in and they sought to take over the election process, which was quashed. This said clause of the Memorandum of Society under the Act does not show that election of the KDTOA to be conducted by the advisory board. It shows that the advisory board is authorized to exercise some extraordinary powers to deal with emergencies subject to reference by the president. It seems that no extraordinary or emergent situation has arisen in the present case for the advisory body to take over the office of KDTOA. However, the ADM had impugned letter dated 25/2022 has directed the advisory board of the KDTOA to take over the office of the KDTOA and initiate necessary action for the election of the next governing body of the KDTOA by 30/9/2022. So also in the impugned minutes of the meeting dated 23/2022 held in the chambers of the ADM, it was decided to direct the members of general body to enable the advisory board to take over the office of KDTOA to process and complete the election by 30/9/2022. In such view of the matter, the prayer of the petitioners is allowed. The impugned letter dated 25/2022 issued by the ADM and the impugned minutes of the meeting dated 23/2022 held in the office chamber of the ADM are hereby quashed. Additionally, it has been brought to the notice of the court that office bearers have already started the process for conducting election of KDTO in the month of September 2023. The district administration is at liberty to take any such steps as permissible under law. In case any law...
Mr. Mahapatra, so wasn't that earlier order brought to the notice of this court, of the single judge?
That has been considered, my lord. That has also been considered.
Then what is it?
In any case, law and order situation arises in connection with the election. So it was only limited to only law and order situation.
So this order is subsequent to the order which you are challenging in this writ appeal.
Yes, my lords. And same single judge, my lords, has passed the order. That is why there is inconsistency, my lords. Same single judge has passed that order. And single judge has also said that in this case, only the limited role of the administration is to provide law and order support. The election process is going on, my lords. There is no occasion for the ADM to interfere here.
All right, yes, that we find that as such in the Orissa's, the state, Orissa Societies Registration Act, there is no provision granting even the power to the registrar societies to interfere in the election process. So that will be the natural corollary that any dispute relating to the election arises amongst the members of the society, they will approach the civil court only then.
My lords, that is exactly, my lords. They'll approach the civil court. They will take shelter of the civil court.
We just interfere with the. I'm asking the counsel for the respondent that we also allow the election process to go on and refrain the additional district magistrate. Of course, the law and order situation will be taken care of by the local police station if anything is there. So let it go. Election can go.
My lords, the problem is first, he has not served me a copy of the writ appeal. I don't know what grounds he has taken. Second of all, in the law and order situation, if the secretary is not allowing the election to take election to be properly conducted, therefore the ADM has the power to step in because, my lords, it's a law and order
ADM
situation.
cannot. The police station can. Superintendent of police can.
My lords, he's not letting the elections happen. It's been more than 9 months. He's not letting the elections
All
happen.
right, we are directing the law enforcing authority to keep a watch. If there is anything, any support is required, they will extend it.
But my lords, now what he is doing is challenging the voter list. Again, the voter list will be quashed. Another new voter list needs to be published, and then the elections will again.
No, we will not accept that the argument that ADM has published the voter list. That there is no proof of that.
Then, my lords, I have no grievance regarding that.
No, my lords, that is there, my lords. That is last page of the impugned order, last page of the present.
No, you show the voter list. Impugned order will not.
The list will go into multiple volumes, my lords. I have shown the publication of notice.
My lords, I have
That
no
is
issue
at the
with the
BS.
voter list.
My lords, page 67 may see. My lords, page 67, annexure 7, my lords. My lords, pardon me, it's in Oriya. I take the help of Ladyship Justice
I
Ratho.
cannot. That is the Oriya text.
My lords, it is mentioned. It is at the BS of the advisory board, my lords. Upadeshta Nirbachana Parichalana Mandali. The advisory board has published this advertisement for final elections, my lords. This publication is made at the BS of the advisory board.
Who formed this advisory board? Who formed the advisory board?
Lords, by misinterpreting at the BS of the ADM, my lords, the advisory board was constituted.
Who formed the advisory board? ADM?
ADM, my lords.
Because the term had expired, there was no ruling body to take care of the society's grievances. For 9 months, they have been expired. It's been more than 2 years. They are expired. They're not taking any step for a new body to be elected. Their term has been expired. They're now trying to subvert all of this in order to now raise these issues and subvert
the source of the
which
power,
has
my lord,
already
I
been
asked
expired, my lords.
My lord, may I see page 51?
If the tenure is expired already, who will hold the election?
Mine since 2 years. Since 2 years. Therefore, after
Who
that,
will hold the election? Tell
then the
us.
advisory body is formed, and then the election is supposed to be held, my lords.
Whether your bylaws provides anything in such circumstances, what?
My lords, may give me time. I'll produce the bylaws. I will satisfy my lords in this respect.
My lord, two paragraphs of the order, your lordship, may kindly see page 51. That is part of annexure 5. Page 51, my lord, you can see. Paragraph C and D. Well, that is why ADM came into picture. Page 51, paragraph C.
Yes.
This code by the order dated 27/10/2022 passed in WPC number so-and-so Balaram Rao versus State of Odisha issued the following order. Though the Land Council for the state raised objection of the maintainability of the writ petition, but in view of the limited nature of grievance of the petitioner, who is a member of the association, the opposite party number 4 additional district magistrate Keonjhar shall do well to issue necessary direction to the advisory board of Keonjhar District Owners Association, that is opposite party number 7, in term of annexure 5 and 6, for initiating necessary action for election of the governing body of Keonjhar District Truck Owners Association office within a stipulated date. Then paragraph D. Accordingly, by letter number 2196, that 31/10/20, instruction has been issued by the ADM to the advisory board to conduct election of the governing body of so-and-so on 25/11/2022.
That is the power they are challenging. Where from ADM comes?
No, that is the direction of this honorable court.
And that direction was not challenged.
No, probably they have not challenged that one.
My lord, subsequently, what is the scope that the ADM can exercise, the advisory board can exercise.
No, just this whether this Mr. Mudali is stating that this order dated 27th October 2022, did you challenge that order?
Because that has not been challenged, my lord. That
In
has
fact,
not-
we have
So that
annexed
is-
it. It's annexed 6. It is annexed that order.
My lord, that is in fact part of this order. This court was conscious of this order of the 1/8/2023 judgment.
So that
And that
if
was
you have not challenged that order, it is binding on you.
Well, as far as the advisory board is concerned, they had a limited role, and therefore that role for elections, that has now been clarified by virtue of order 1/8/2023. The composition of the advisory board is not disputed, my lords, but the role in the election process is disputed. My lords, that is what this.
But you read this order that has been quoted in this para 6, page 51.
My lords, it says initiating necessary action for election of the governing body.
No, though the learned counsel for the state raised objection of the maintainability of the writ petition, but in view of the limited nature of grievance of the petitioner, who is a member of association, the opposite party number 4, additional district magistrate Kionchor, shall do well to issue necessary direction to the advisory board of such and such district track owners association, i.e. opposite party number 7, in terms of annexure 5 and 6 for initiating necessary action for election of the governing body of the association.
Well, that is what has been considered by the single judge. And at page 55, he has clarified that the role that the advisory board is to perform. My lords, may see page 55, my lords. Page 55, my lords, which I placed, my lords, sometime before.
No, all right.
My lords, page 55.
So you are not aggrieved by the direction to hold the election, that you're not aggrieved.
We are not aggrieved. But as far as the role of the ADM is concerned in the election process, we are aggrieved by that, my lords. My lords, page para 18,
He
my
has
lord.
only directed the advisory board of your association.
The advisory board is headed by is composed of members of the government, my lords, of the ADM and other members of the.
Now, whatever I do not know, that advisory board was there and who take notice of this
My lords,
existence.
for a
of the
moment, my
advisory
lords,
board.
for a moment, I draw your attention to para 18, my lords, of this order itself, my lords. Para 18, page 55, which I placed sometime back, my lords.
Yes.
They have referred to clause 4C of the advisory board's power under the bylaws.
Oh. Take over the office of the initiative.
It says that the clause of the memorandum of society under the act does not show election of the KDTOA to be conducted by the advisory board. It shows the advisory board is authorized to exercise some extraordinary power to deal with emergency subject to reference with the president.
No, they are authorized to exercise some extraordinary power to deal with emergency.
It seems that no extraordinary emergency situation has arisen in the present case for the advisory board to take over the office of KDTOA. However, the ADM by impugned letter dated 25/2022 has directed the advisory board to take over of the KDTOA to take over the office of KDTOA and initiate necessary action for the election of the next governing body of the KDTOA by 30/9/2022. So also in the impugned minutes of the meeting dated 23/2022 held in the office chambers, the ADM, it was decided to direct the members of the general body to enable the advisory board to take over the office of KDTOA to process and complete the election by 30/9/2022. In such view of the matter, the prayer of the petition is allowed and impugned letter dated issued by the ADM, my lords, was quashed.
Mr. Mahapatra, then who will conduct the election? Somebody has to do it.
The governing, my lords, the governing body will do it, my lords.
But your term
That is
has
what-
expired.
Governing body, how can the governing body's election? How the
Term has
governing
expired
body can hold the election?
Had they done it?
My lords,
My lords,
any
election of the
association,
governing body.
my lords, any association, my lords, for an example, like the Bar Association of this.
If you agree that we can make one arrangement by exercising our power, we appoint someone as the election officer to conduct the election.
My lords may do that, my lords. That's
You have to agree because since there is by law there is no provision. You have to come on terms on yourself. Then the subdivisional magistrate will request subdivisional magistrate to hold the election. Limited power will be granted to him the publication of the electoral roll and conduct the election free and fairly. But you have to give consent to that.
my lords, I'll take instructions. I don't have express instructions regarding this.
All
I
right.
think my lords may fix
The
it
matter
some
will be
way.
listed on 31st of August 2023 as parted. Meanwhile, the counsel for the parties shall obtain instruction from their respective parties whether they will be agreeable if an election officer is appointed by this court for conducting a free and fair election. Stop. We also like to expressly mention that the said publication officer shall also publish the draft voter list, invite the objection, and settle the matter in order to conduct a free and fair election.
My lords, may I pray that an independent election officer, bereft of any government interference.
This is this person will go and there because he under his command, police will be there and everything is there.
My
Who
lords.
is the independent person? We cannot send any judicial officer in this matter.
My lords, I'll come back on this, my
All
lords.
right, otherwise we have to pass the order. What to do?
My lords.
My lords, may I
Aviator in the meanwhile.
I have sought, my lord.
My lords, may I request that a copy be served to me at least, my
Already.
lords, Mr. Aviator.
By tomorrow.
I have sought today, my lord.
Mr. Sanganeria, where are you?
My lords, I'm in Delhi. That is the reason why, my lords, I'm appearing.
Go by
No,
email, it's all right.
Both are in Delhi.
Just exchange the email and or otherwise you just name a associate lawyer here.
He's
and
there.
serve on him.
My lords,
I'll serve him.
I have sought, my lord.
you can
Okay,
serve me
he's
a
there.
soft copy also, my lords. I'm okay with the soft copy, my lords.
All right.
We'll serve it.
That's why I'm telling you.
I think, yeah, associate is present in court.
So
Yes, my lords, he is present.
copy of the memorandum of appeal is served to the counsel with the respondents who have appeared on inspection in the proceeding by tomorrow.
I'm highly very grateful.
Extremely grateful, my lords, for the patient hearing.
My lord, I have filed the authorization copy of the authorization copy, my lord. Authorization copy, my lord.
What is authorization copy?
So he means probably memo of appearance, my lords.
Memo of appearance.
My lord.
That you've already passed the order.
Published.
You have filed the this.
Because I was not holding the power, probably that's the reason he's filed the memo of appearance. my lords.
Mr. Mahapatra, I think you have the power.
I didn't have the power, my lord, so I filed the memo of appearance. Mr. Dilip has filed the memo of appearance on my behalf.
Mr. Prasenjit Mahapatra, that council has filed the powers to appear to the appellant.
Highly obliged, my lords.
Grateful, my lords.
Call the other.
Item number 20.
Please.
Challenge the order of the honorable single judge.
Your writ petition has been rejected.
Rejected, my lord. I challenge on 3 grounds, my lord. That the applications which were invited on the basis of the
Who
guidelines,
is appearing for the respondents?
Mr. S.K. Naik, private respondent, who has been appointed. For respondent number 6, my lord.
Respondent number 5 has also filed the affidavit in this writ appeal.
They have not served the copy on me, my lord.
Mr. Kuntia?
Normally, I should not file an affidavit in writ appeal.
No, you have not supplied the copy because you filed the affidavit by the one child development project officer.
No, they have not served copy.
Files.
No.
He is also
No,
in
they have
charge
not
of the
served.
CDPL. You have not received copy?
No, no.
Receipt. 138.
Signature is there. Yes.
Advocate for the petition.
Not his supply copy. We'll take up the matter on 24th. 24th. List it again. Counter affidavit filed by the respondent 5. Copy of the counter affidavit filed by the respondent 5 has not been served in the council of the appellant. Meanwhile, such copy shall be furnished to Mr. M.K. Mohanty, and counsel obtained for the appellant. Mr. M.K. Kuntial and counsel appears for the opposite parties number. Opposite parties.
Number 21.
Please, my lords.
Transfer to me, my lord. Some documents are missing from my side. I have requested my friend to supply.
I have.
The
The matter was being finally argued.
It is no stay order.
I'm asking for Development Authority. I think the lot of applicant to one point, Lord. I have filed one memorandum, and then my lord on 13/4/2021 at 5 a.m. And that memorandum I have supplied a copy of the petition, which is analogous, identical to the petition. This petition has been filed by the apartment owner, and that petition was filed by the landowner. Where the landowner's petition was dead, it will not benefit. And by order dated 2007, my lord, your lordship, this honorable court has dismissed that petition, saying that it cannot order read within petition, it cannot be maintainable, and it should be hard and and that document I have filed. I seek that your doctor can call for that file. Document number 4242/2008.
Repeat the number again.
Again.
The WPC number?
WPC number 4242 by 2008 is posted on February 2017.
I am for my lords opposite party number 6 and 7. For a second, I draw your lordship's attention to the prayer here. I am for the GA department. My lords, all these lands have been, my lords, allotted and leased out by us, the GA department, who's in charge of all the urban lands in Bhubaneswar, my lords. Lordship may kindly come to the prayer, page 15 of the writ petition. How can, my lords, such a prayer, exactly what your lordship was observing a few matters back, my lords. A writ of mandamus be issued to quash order dated so and so, passed by Government of Orissa under GA department, wide order number so and so GA, the same is illegal and void. We have already leased out that portion. The next, my lords, this is even more, my lords. A writ in the nature of mandamus directing the state authorities to demolish the illegal constructions raised by opposite party number 5 on the land in question, as per provisions of law. We have leased out to a hotel who's running there. And further, and not only this particular hotel, we have leased out to so many hotels in that area as a part of the general development plan for the entire area, the capital city of Bhubaneswar, my lords. And further, be pleased to direct BDA and BMC to develop the land in question. There is plot number B4, corresponding to revenue plot number 284, Khata number 144, as a community park. For this, my lords, for this.
What kind of a petition filing this before the
And
court?
then they come and say that the lease was, then they divert the attention in a miscase by way of a side wind, my lords. They come in and divert the attention of this honorable court to a CAG report, saying that land had been leased out at throwaway prices and all that, my lords. Then court calls for a report, we give it that.
You go to the Lokayukt.
Yes, my lord. This writ petition, my lords, is the abuse of process, my lord. Any further interference is abuse.
One opportunity, my lord. I have requested my lord.
This prayer was made on the last occasion. The earlier council had almost, my lord, the matter was concluded.
Just
hearing
to see the last order.
Yes, my lord. So, how
Last
can my
order,
lords-
you see that how many times that can be done.
my lord,
And the main writ is so small, my lord, is in a limited ambit. And then they go on expanding, my lords, and against one hotel and one plot of land they want.
a forest land, my lord, without reservation, that cannot be allotted.
The entire issue
And
is-
that has been allotted by the outgoing chief minister of the state, my lord, late Hemanta Vishwa, my lord. When the result was declared, the assembly election result was declared, and the BJD coalition government, before formation of the government, my lord, by exercising discretionary power, the then chief minister allotted the land in favor of the number 5. And in the CAG report also, my lord, all the documents are not with me, my lord. Only one
Government-
opportunity given to me, my lord.
We are just providing because he is a new entrant. We are fixing the case some other day.
Along with that writ petition.
Along with that writ petition. Can be done also 27, 20. 29 and 30. One case, old matter that is your 2012, huh? Okay, 29. At the request of Mr.
NC man.
NC Mohanty, Learned Council, appearing for the petition. Let the matter be listed on 29 August 2023. It is made absolutely clear, along with this matter, along with the concerns disposed of. It is made absolutely clear on that day there shall be no accommodation.
Grateful.
Mr. Subir Pali, senior advocate, has appeared for the general. You are for
General Administration Department, opposite parties 6 and 7.
Opposite party number 6.
6 and 7.
Mr. Mohanty is not there. Ashok Mohanty is here there. Mr. Ashok Mohanty, senior advocate, has appeared for the opposite party number 5. And you are appearing for whom?
Development Authority, opposite party number 4.
All right, Mr. Sachin sir, council appears for the opposite party number 4. You are appearing for Mrs. Party.
BMC, Your Lordship. Opposite party number 3, BMC. I'm appearing on behalf of Mrs. M. Padi.
What is your good name?
Piyush Panda.
The Piyush Pandal and council appears for opposite party number 3 on instruction of Mrs. MS M. Padi, Learned
Yes, Your
Council,
Lordship.
for the Bhubaneswar Municipal
OP
Corporation.
number 3.
All right, OP number 3. Oh, you have already tagged it.
Grateful.
The rest of the matter, postmaster will provide the date.
Item 54, personal appearance was there at the party. Now that your lordship is rising, you see the other side has also come, and now that this is the next Friday also. Next 2 weeks, I will not be there for the
Only the next to the next page, what is the date?
Friday is not so clear.
We are fixing it on 1st of September, is it all right?
He is not saying September.
Oh, okay. On 8th of September? Then it will come on 8th of September. Not on Friday. So not on Friday, so the whole day can be consumed. All right, Mr. Mohanty. Will you find the date where 2 p.m. can be given and on that date? Yes, we are providing. You are searching out this. Thirty-first, it will come. 31st.
Item 25.
No, in the registry, because it's 31st, we fixed.
Item 25. 25. The interim order is still to them.
Interim order, give a date in 19th. 22nd of September. Meanwhile, the interim order is passed earlier shall continue. Well,
The serial number. What is the serial number? There is no 58. Aji nahi?
you call 52, 53, 54, three matters called.
Your Lordship, I am sorry, that was not 54, that is 53 I was mentioned.
Just a minute.
I don't know, 52.
Mr. Kotuki is not there. We'll take up the matter. Other matters we don't follow.
Item 31, 31, 32, interim orders.
The same order, no?
Same.
In the next interim order is possible, shall continue.
Same prayer in item 35 and 42 and 40.
35 and 42.
And 40, man. For the
22nd September, no?
Right.
All the 22nd
22nd
September. All right. Any other matter?
40, 40.
40 same, no? 22nd. Till interim order is there.
Right.
All right.
Number 1, ARBP 37 over 2023.
Please, Your Lordship, my lords. This is an application under section 11(6) of the Arbitration Act. The clause is at page 50, if Your Lordship may kindly peruse.
Have you annexed the agreement?
My lords?
Have you annexed agreement?
Yes, my lords. The arbitration clause is at page 50. That is the running portion of the agreement, my lords. Page 50, Your Lordship may kindly see. Lords, may I place it? Lords, I'll straight away draw to my lord's attention. Lords, the dispute redressal committee along with the list
So
of.
you had approached the difference?
Yes, my lords, that there is an order to that effect.
So it has not been amicably settled?
No, my lords.
All right.
That is at page
What is
40.
the notice here?
My lords.
Arbitration notice annexure 15?
Annexure, page 52, my lords.
Annexure 15?
My lords, annexure 15, page 52. No, my lords, annexure 15, page 52 onwards.
Yes. Anybody is appearing for the?
Yes, we are appearing.
We refer?
The first time it was listed, let's not keep it to next week.
No.
Clause 25 is a clause, Lordship may come to page 49.
That you have seen.
Yes.
They say that
Settlement of
the
the dispute of arbitration.
reconciliation totally failed.
Yes.
So they have given the notice. What more is required? You refer the matter to an arbitrator, you appear there.
No, we will appear, but unless something the first time it was listed, so we will take certain instruction, otherwise Lordship may pass.
What instruction in this?
Otherwise, my lord, what happened? Suppose sometimes what happening, I'm just
That is
clarifying, my lord.
the basic thing we have to examine whether there is an agreement.
No, yes, my lord.
Whether there
What,
is a clause, whether the notice has been given and the breakdown of the reconciliation.
my lord, what
process.
happening? The department have a own arbitration panel. Sometimes they are appointing arbitrator. We are appointing another order here. That's why only.
That has not happened so far. That is why they have approached us.
No, my lord. No. It is
If
happening.
if you have any arbitrator's name in mind, tell us.
It is wrong, my lord. I am admitting that without the consent of the court, they cannot happen. I am admitting.
No,
that.
they can refer because if the arbitration courts permits, then they can refer. Already the 1st of September. Mr. Shudip Pandal and counsel appearing for the petitioner. This is a petition for referring the dispute as
Dispute relates to, my lord, service tax demand.
Huh?
Dispute relates to service tax demand.
No, dispute, no, that is why I am not going. Dispute is reflected in the notice dated 25/4/2023, annexure 15 to the reputation. Issue notice since Mr. Here, Mr. SS. Kashyap, yes, Kashyap Council. Appears in which notice for the opposite parties. No formal notice is called for. Notices may be written on 1st of September 2023. So I should reflect your name, Mr. Pari, also.
Yes, yes.
Mr. Pari also. Mr. Pari. For next item.
Item number
I'm
2.
grateful, my lords.
I am appearing for the opposite party, my lord. There is a noting in this list. The coordinator has, arbitrator center has intimated that this arbitrator has relinquished to substitute some other arbiter. But I don't have a copy. If my learned friend has given a copy or anything, we can collect from the.
You want to see this coordinator's report?
Maybe because noting is there. We don't have a.
This just is the physical record. Show the report. This flag 10. To him, not to me. Why the arbitration proceeding was asked to draw? Is there any agreement? Who is appearing for the petitioner?
My lord, I am appearing.
What happened there?
On behalf of Mr. Siddhant Dwivedi.
What happened there?
My lord, agreement, my lord, is that clause 64 of the GCC, my lord, is the appointment of an arbitrator, my lord.
No,
my lord, in this,
my
lord, in this arbitration proceeding, my lord, the opposite party filed a section 16 application regarding the biasness of the arbitrator.
Okay.
Yes, this application.
That is,
Lordship, any
So that-
account, any arbitrator.
My lord,
senior advocate.
my lord, I'll give some names.
Shishir Das is emperor now.
My lord, I have 3 names. May I?
Or any retired decisions.
Do you have any suggestion?
Yes, my lord. My lord, senior advocate Sri Manoj Mishra. Second preference, my lord, senior advocate Sri Durga Prasad Nanda. And third preference, Sri Ramakant Mahanti, senior advocate.
I don't have any objection. Any.
No, all right. Just I'm seeing over the present load on that. Just I'm there. Mr. Durga Prasad Nando is an empaneled arbitrator.
No, my lord.
You have no idea.
No, my lord.
Mr. Mukherjee, we like to appoint you as the arbitrator in one matter. Stake is very small.
Yes, yes.
I don't think you have any involvement between the parties.
Except for that.
All right.
Item one, item two.
Really, Mr. Kanungu actually faced certain section 16 objection. All right. This court has been informed that Mr. Milon Kanungu, senior advocate, was appointed by this court as the arbitrator, as relinquished, as there was some objection in the section 16 of the Arbitration and Conciliation Act 1996. Stop. As such, there arises a requirement of appointing a fresh arbitrator for the same dispute. Stop. The council appealing to the parties have agreed that Mr. Gautam Mukherjee, the senior counsel, can be appointed as the arbitrator to adjudicate the dispute arising from the agreement dated 21/1/1999, Annexure 1 to the ARB 40 of 2018. Stop. Okay. Mukherjee, the senior counsel, is appointed as the arbitrator to adjudicate the dispute and make the award in accordance with the provisions of Arbitration and Conciliation Act. So, a copy of this order is sent to the coordinator, High Court Arbitration Center. So, the parties, Mr. Mukherjee, we fix a date. If you give the date straight away, they will appear. In the month of September, I think it will be better. You prefer Saturday?
Friday at 4:20.
So appeal 15th September. The parties shall appear before the arbitrator on 15th September 2023 at 4:30 p.m. at the High Court of Orissa Arbitration Center. A copy of this order be communicated to Mr. G. Mukherjee, Leonard Senior Counsel, and the coordinator, High Court Mediation Center, Proceedings. The interlocutory application therefore stands disposed of.
Item number 3.
Obliged, my lord.
May it please your lordships, my
My
lord.
lord, item 2 along with me, Mr. Baisar, Raiguru is appealing.
Okay.
My lord, item 3, my lord, may it please your lordships, my lord, I appear for the petitioners in this matter, my lord. My lord, this is my application under section 11 where pleadings are complete. My lord, the agreement, my lord, if your lordships may, and the arbitration clause, if your lordships may, comes to my lord, page 23. My lord, the existence of the arbitration agreement has not been denied by the, my lord, the respondents. My lord, the respondents have filed a counter also, my lord, wherein they have stated that they have also admitted that there is a dispute. The only stand they have taken is that I had also, my lord, approached the National Company Law Tribunal because, my lord, the issue was dispute is regarding, my lord, some transfer of the shares, my lord, which they refused to do under the agreement, which your lordships knows, my lord, under section 59, I have to, my lord, go to the National Company Law Tribunal. Now, my lord, since they breached the contract in question, well, I have invoked the arbitration clause to claim damages, I have also handed up a schedule of disputes, as was handed up to your was desired by your lordships on the last occasion. But if your lordships may see the schedule of disputes, I have highlighted what are the disputes which has to be adjudicated by the arbitral tribunal. One, of course, is claim for damages. The entire money paid has to be returned with interest. And they also, in their reply affidavit, admit that they have to refund this money. The question is, when or how much would be the quantum of damages? That has to be only adjudicated. So, the existence of the arbitration clause is not denied by the respondent. The respondent admits that there is a dispute between the parties, and if your lordship sees from their very reply to the section 21 notice, he also admits that the intention of the parties is to go for arbitration. May I just show 2 pages to your lordship? Page 23, if your lordship comes to, that is the arbitration clause. Page 23 of my petition,
Yes.
Let's clause 15, if I may place, that this MOU shall be constructed and interpreted in accordance and governed by the laws of India, and courts situated in Rourkela, Orissa alone shall have the jurisdiction in all or any matters including arbitration petitions arising out of in respect of this MOU. Further, in the event of any dispute arising between the parties to the present MOU, the same shall be earnestly endeavored to be mutually and amicably settled between the parties. However, in case there still exists or arises any matter of disputes in respect of the subject matter of this MOU, the same shall be referred to the arbitrator through mutual consultation and agreement by the parties to the agreement. Now, my notice thereafter is at page 72. If your lordship comes to 72, I gave them a notice on 21st of May 2022 at page 72. And at page 73, we had indicated the name of the arbitrator at page 73, last paragraph. And your lordship would see their response at page 75.
Yes.
They received the notice at page 75 by a letter of 30th June 2022. And your lordship sees the last paragraph: in the background of the aforesaid facts and circumstances, your unilateral appointed of an unknown person arbitrator of your choice without our consent does not make any sense. This is what they say, in the reply to the section 21 notice. They also admit that the intention of the parties was to go for arbitration. Your lordships may appoint anybody as an arbitrator, and if parties mutually consent, that can happen in the arbitration center of the High Court itself. And your lordships should also see, they have stated at page 75, the second last paragraph, that you will appreciate that we have already refunded a substantial sum and assure you to liquidate the entire amount within a short period of time by maintaining the continuity of our regular payments. Now, this they had stated on 20th June 2022. We are in August 2023. And if your lordships kindly take up their counter affidavit once, which they have filed, kindly comes to paragraph 13 of the counter affidavit filed by my learned friends. If your lordship is with me, in paragraph 13 of the counter.
Yes, please.
Yes, may I, with your lordship, place it, that it is humbly submitted that the opposite party number 2 had made it clear through its WhatsApp messages to the petitioner number 3, an authorized representative of the petitioners, that he is not willing to transfer the shares unless the MOU has acted upon in full letter and spirit. Further, the reply to withdraw from the arrangement and return the advance amount is also to be considered for the present dispute. So he acknowledges that there is a dispute. For the present dispute, this has to be considered. And then he says that in the facts and circumstances of the case, the opposite parties are always willing to settle the outstanding dues along with interest, to which the petitioners also agreed initially. And the same is well established from the very conduct of the opposite party by way of repayment that has been done till date. Therefore, the opposite parties be allowed to return the remaining amount as agreed by the parties, and the present petition may be dismissed. So, what they want is that they want time to make payment, but I will ultimately, for the breach of contract on their part, will have a claim for damages, for which I have to go to before the arbitrator. So he acknowledges that there is a dispute. He acknowledges the fact that there is an arbitration agreement, that the intention of the parties is to arbitrate. And he has responded. My section 21 notice has been served upon him and he has responded. So, Malaj, I'm humbly praying before your lordships, Malaj, kindly appoint anybody, Malaj, which your lordships, Malaj, this honorable court may deem fit and proper, Malaj. And if, Malaj, Malaj, it can be held, Malaj, in the arbitration center, Malaj, Malaj, associated with the High Court in Cuttack, Malaj. Those are my respectful submissions, Malaj.
I am for the opposite party, your lordship.
Yes.
Yes. If your lordship sees, my learned friend has already indicated by page 23 the arbitration clause, your lordship. Arbitration clause at page 23. The second part of that clause says, however, in case of there still exists or arises any matter of dispute in respect of subject matter of this MOU, the same shall be referred to the arbitrator through mutual consultations and agreement by the parties to the agreement. Now, then they served section 21 notice at page 73.
And they have suggested
Yes,
one
yes.
name.
I'm just, they have suggested a name. Now they have what, in exercise of the matter, clause 15 MOU, we have to invoke arbitration clause and we suggest so and so name. And the next page, is my reply that unilateral initiation of arbitration procedure is not as per the MOU, as per the arbitration clause. So that is not. The arbitrator has also issued a notice to me. I am referring to a judgment of your of Delhi High Court, your lordship. Wherein section 21 notice, what is the importance of section 21 notice, your lordship? Justice Dr. Muralidhar, as was then was in Delhi High Court. If I say, may I take page, internal page 9, your lordship, para 23, your lordship. May I place, your lordship? Is the notice under section 21 mandatory?
Yes.
The page, then 24 is para 24, section 21 has been reflected. It says the commencement of arbitral proceedings, unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Now, section para 25 says a plain reading of the above provisions indicates that except where the parties have agreed to the contrary, the date of commencement of the arbitration proceedings would be the date on which the recipient of the notice, the petitioner herein, receives from the claimant a request for referring the dispute to the arbitration. The object behind the provision is not difficult to discern. The party to the arbitration agreement against whom a claim is made should know what the claims are. It is possible that in response to the notice, the recipient of the notice may accept some of the claim either wholly or in part, and dispute between the parties may thus get narrowed down. The second is that in one aspect of the matter. The other is that such a notice provides an opportunity to the recipient to the notice to point out if some of the claims are time barred. Third is para 26. And importantly, where the parties have agreed on a procedure for the appointment of the, this is important, your lordship, where the parties have agreed on a procedure for the appointment of an arbitrator, unless there is such a notice invoking the arbitration clause, it will not be possible to know whether the procedure as envisaged in the arbitration clause has been followed. Invariably, the arbitration clause do not contemplate the unilateral appointment of an arbitrator by one of the parties. Then fourth, para 27. Fourthly, even assuming that, I will straight away come to para 28, your lordship. That is important. Lastly, for the purpose of 11.6 of the Act, without the notice under section 21 of the Act, a party seeking reference of dispute to arbitration will be unable to demonstrate that there was a failure by one party to adhere to the procedure and accede to the request of the appointment of an arbitrator. The trigger for the court's jurisdiction under section 11 of the Act is such failure by one party to respond. Here is the case where the arbitration clause, as per the MOU, says mutual agreement, mutual consultation. Section 21 invocation by the petitioner is only by referring to one single arbitrator without following as per the MOU. Then on my response,
why don't you just consider this is a proposition for your consideration?
No, my humble submission here is that unless a proper section 21 notice has been given, 11.6 is not maintainable, Your Lordship. That is
There is the law.
Yes, that's the law, Your Lordship. Here, section 21 is for mutual consultation as per the agreement, Your Lordship. Here, they have not done that by invoking section 21, Your Lordship, by the notice. So that if it's a faulty section 121 notice, can it be said that a notice has been served on me under section 21? So this petition under 11.6 is premature, Your Lordship, without a proper section 121. As per this agreement.
Just a minute. Just to come to the another notice is there.
Yes. Only one notice has been given.
Yes, no.
Invoking section 21, which I denied that unilateral, as per the agreement, you cannot do unilaterally. They never served another notice under section 21.
Come to the page, it is 75, I believe.
Yes, Your Lordship.
Come to that.
That is my reply, Your Lordship.
That is there. That is in reply to the 21.
Yes, Your Lordship. I say that as per the agreement, you have not invoked section 21 and unilateral selection of arbitrator is not maintainable because it is not as per the agreement. And hence, that section 21 is faulty, and therefore this section 11.6 petition is not maintainable, Your Lordship. They have to again serve a section 21 notice if as per law, Your Lordship. As per this judgment, I rely upon this judgment solely, Your Lordship.
According to you, this judgment is binding on this court.
Your Lordship, it is because if section 21 is there, Your Lordship, that is the law, Your Lordship, because that has been given by the relying upon Supreme Court judgments. They have this.
That I understand.
Yes, Your Lordship. But it is
this is a contextual interpretation. We have to look into the context.
Yes, sir.
Whether the demand has been formed or not, that has to be only looked into.
Yeah, if Your Lordship says there are 5 contingent that has to be given in section 21. If on the merits also,
yes,
section 21 has to give 5, whether it has time bar or not, whether a proper.
Right, but
yes.
You are not raising any objection.
No, I am saying that these section 21 petition is faulty. That is what my submission is. It is not as per the agreement. The agreement is section 21 also says that, as that's the statute. If the agreement is made for mutual consultation and one party invokes section 21 and says that unilateral appointment of an arbitrator, that is not a faulty 21, and hence this section 11 section is premature, Your Lordship, in failure of a proper section 21 notice.
What is this 17th May notice? Annexure 9?
That is for that is from party, Your Lordship. That you this is seeking this as this not under section 21.
Indicating the disputes, Malak.
Yes, not under section 21, Your Lordship.
No, whether under section 21, section 21 requires certain demand has to be placed for purpose of compliance.
Yes, Your Lordship.
Whether the section 21 has been written or not, whether the demand has been placed, that is more pertinent. That just come to this letter or notice, whatever, just see what the demand has been made in this notice.
Yes, Your Lordship.
So since you have not considered to that demand, later on they have proposed that this will be our arbitrary.
No, they have invoking section 21. If you read the language
that letter they have referred to.
Yes, sir.
But
if Your Lordship sees page 72, Your Lordship, that is invocation of section 21.
No, the 17th May letter you read para 16.
Yes, Your Lordship. Hence, you are requested to transfer the said letter, but not later than 2 days from the date of letter, failing which the MOU and SPA shall stand terminated. You shall be required to pay damages under this is without prejudice to the rights of purchasers to claim interest, penalty, and damages. Yes. We hereby reserve our right, but this is not as per arbitration clause, Your Lordship. It is says that if the dispute you pay, please repay or comply with the MOU, or else the dispute as per damages will continue. But it is not for invocation of arbitration, Your Lordship. This is a notice.
And then subsequent notice should come?
Yes, Your Lordship. This is under section 21, Your Lordship. Yes. But this section 21 is faulty, not as per the agreement as a MOU, Lordship. This is only saying that the clause of memorandum is reflected, the arbitration clause has been referred, and straight away they say that we appoint so and so. Whether it is permissible under section 21.
Yes.
Lord, can I answer? Lord, can I answer?
Just a minute. That is the earlier demand that you have placed, according to Land Council appearing for the opposite parties, it is not a notice under section 21. The 21 notice is only this letter that was
page 72.
Page 73.
Yes, sir. Page 72 at page 73. Correct.
Yes.
Lord,
in that notice, there is no demand. And only a proposition for the thing, whether that can be treated as a notice under section 21 or not, because you have
So,
styled it as a notice under section 21.
Yes, I'll answer that. Let kindly come to page 23 of the arbitration clause, Blood once.
I have seen it.
Yes, Blood, I'm just answering that, Blood. Subject matter of this MOU, the same shall be referred to arbitrator through mutual consultations and agreements by the parties to the agreement. So I have suggested a name of an arbitrator. He has not he has not consented to this, which is why I am here before the section 11 court.
No, the first objection raised that you have unilaterally nominated by stopping the method of consultation. That is
No,
the first
that's what I'm
objection
saying,
raised.
Milord. I have suggested a name. I have asked him to agree. I have not appointed. I have asked him to agree. He has not agreed.
Nominate such and such.
Correct,
So you
correct,
have already
Milord.
nominated it.
No, Milord, nomination is something else. Milord, I'll tell you, Lordship. I'll tell you, Lordship. Milord, section 11, Lordship. When is section 11, Milord, invoked, Milord, by the parties? Milord, when, Milord, there is a disagreement as regards to, Milord, the arbitrator, or parties are not able to agree with the name of an arbitrator. I have suggested his name. He has not agreed, which is why, Milord, I have come here before a section 11. Now, Milord, what my learned friend, I'll just indicate one more thing, Milord. Greatest of respect to my learned friend, Milord. Entire count, because this is a question of fact. Whether I have consulted him, or not, Milord, it's a question of fact. In its entire counter affidavit filed by my learned friend, Milord, not a whisper of this. Not a single pleading, Milord. And today, Milord, at the argument stage, parties, Milord, if parties are allowed to argue outside their pleadings on a question of fact, Milord, greatest of respect, Milord, recently, Milord, I can also rely upon, Milord, now Vidya Drolia says, Milord, Supreme Court says that this court at the section 11 stage has to see, Milord, whether there is a dispute between the parties, Milord, which my learned friend does not dispute, that there is a non-dispute. Whether there is an arbitration agreement, he does not dispute that. Now, Milord, he is not able to say he is on the basis that, Milord, I have nominated or suggested an arbitrator. He is saying that before suggesting the name, Milord, I ought to have consulted him. Milord, that's why, Milord, I have approached this court, because I have made a suggestion under the section 21 notice. Because whenever I give a section 21 notice, Milord, if I give a section 21 notice, I have to name an arbitrator. Without naming an arbitrator, Milord, I cannot give a section 21 notice, with greatest of respect. My learned friend is completely, and this judgment rather, Milord, helps my proposition. We are not able to agree on a name of an arbitrator. Yes, I had suggested a name. He has not agreed the name of the arbitrator, which is why I am here before the section 11 court, Milord. Section 11 only come, Milord. Otherwise, Milord, if you would have agreed, Milord, kindly also sees this. Milord, in response to the section 21, he does not suggest a name. He does not say that please let us also consider this particular, Milord, person as an arbitrator. He does not say that. But if my learned friend was so interested in mutually consulting each other, Milord, we are before your lordships, we agree on an arbitrator right here and now. Why? Or your lordships may do that. In the kindly series his response to the section 21. He could have said, I am not agreeable to this. I am suggesting Mr. Y or Mr. X to be the arbitrator. He does not even do that. So, Milord, admittedly, the consultation has failed and we are before your lordships under section 11. So, Milord, without invoking the arbitration clause under section 21, without naming an arbitrator, how can I even discuss this with him or go even into a mutual consultation with him? Because your lordships, what your lordships had seen, I have already issued a demand notice prior thereto. Milord, the disputes have failed, the consultations have failed. He has not, Milord, responded to that. Thereafter, I have invoked the arbitration clause. Okay. Milord, those are my respectful submissions.
May I just reiterate one thing, Your Lordship?
Nothing is there because if the two letter and the demand is read together,
yes, Your Lordship,
it is a culmination that they have raised the dispute. The dispute was not ameliorated by a process of consultation, and then they propose the name. Though the word is nominate is a little bit misplaced.
To that, Your Lordship, if Your Lordship comes to page 76. Page 76 is that arbitrator who himself writes to me that I am the arbitrator, come and surrender before me. under my jurisdiction. Page 76. It is not an it is not a suggestion, Your Lordship. It is a nomination.
Well, since he has not agreed,
let me complete, my friend. Let me
All right,
complete.
that will.
And to that, I have returned to reply to the learned arbitrator.
Going to appoint that person.
No, I'm not there, Your Lordship. So it is not invoking section, the arbitration clause, Your Lordship.
That point. That it is not the invocation of the section 21.
The trigger point of 11.6 is section 21, Your Lordship.
Yes.
So that 21 is, if it is faulty, my humble submission is that 11.6 is not pending.
Decide wait, that court will decide this point. Yes, Mr. Pari was appearing for whom in the last occasion? D.K. Pari, I think he is not involved in the matter.
No, Your Lordship.
This is wrongly.
And one thing, Your Lordship, out of 5 crores dispute, almost 3 crores has already been paid to them with 18% interest, Your Lordship. And they are accepting it. It is not that they are in dispute. So the term dispute is may not be disputed, but their acceptance of money is not also disputed, Your Lordship.
That in your statement you say there before the arbitrator.
But my this proposition may also be cleared, Your Lordship, that invocation of 21 is mandatory, Your Lordship.
All right, that will decide whether that has been complied with or not.
Yes, sir. Grateful.
Yes. Third, Mr. R. Banerjee and Counsel. Appearing on instruction of Mr. Anupam Das.
Yes, my lords. Yes, my lords. Yes,
Anupam Das and counsel for the petitioner. And Mr. Who is appearing for the response you now?
I am for B. Panigrahi.
B. Panigrahi. The land counsel appears for the opposite parties. This is an application under section 11C of the Arbitration and Conciliation Act, seeking appointment of the arbitrator for adjudication of the dispute is raised by the petitioner. Stop. There is no dispute that the clause 15 of the Memorandum of Understanding dated 27/10/2019 provides the arbitration clause in the following manner. In the event of just before that, any dispute arising between the parties to the present MOU, the same shall be earnestly endeavored to be mutually and amicably settled between the parties hereto. However, in case there is still exists or arises any matter of dispute in respect of the subject matter of the MOU, the same shall be referred to the arbitrator through mutual consultation and agreements by the parties to the agreement. Stop. The dispute was raised What is this 17.5 letter?
Let's page 65,
Section
my
nine.
lord, if your lordship, 65.
Raised by the letter dated 17/5/2022, connection 9 to this petition. By the said letter, after giving the background of the disputes, and the dispute, it has been demanded that the opposite party shall transfer the sale shares immediately, but not later than 2 days from the date of the letter within bracket notice period, failing which the MAO and the SPA shall stand terminated. You shall be required to pay damages and this is without prejudice to the right of the purchasers to claim interest, perhaps interest, penalty and damages. Stop. It has been stated by the petitioner the demand was not complied with, and consequently complied with. Stop. In response to the said demand, now in sequel to the letter dated 17/5/2020, the petitioner had given further letter styling the same as the notice under section 21 of the Arbitration and Conciliation Act 1996. So having referred to the clause 15 as a whole, it has been demanded that the arbitration clause was invoked, and Mr. Jagannath Patnaik, advocate of High Court, as the arbitrator, has been nominated to adjudicate the dispute arising from the said MOU and SPA. Stop. In response to the said letter, dated 21/5/2020, annexure 10 to this petition, the opposite party has stated as stated inter alia that most unfortunately, for the reason best known, when we commenced repayments of our investment, you started demanding transfer of our shares, followed with the proceeding before the NCLT and the criminal case in the court of SDGM Rourkela, and both proceedings are still subjudiced. It has been further stated in the said letter that the opposite party, by the said letter, the opposite parties have further claimed that they have already refunded a substantial sum. Stop. They had also assured that they would liquidate the entire amount within a short period of time by maintaining the continuity of our regular repayments. Stop. Thereafter, it has been observed as follows. In that background, the aforesaid facts and circumstances, you unilateral appointed SIC appointment of an unknown person / arbitrator to your choice without our consent does not make any sense. Unquote. In this perspective facts, the present petition has been filed by the petitioner seeking the reference to the arbitrator for adjudicating the dispute as noted above. Stop. Mr. So what is your good name?
B. Panigrahi.
Mr. B. Panigrahi, learned counsel appearing for the opposite party, raised serious objection regarding the maintainability of this petition under section 11(6) of the Arbitration and Conciliation Act. As according to him, there is no notice under section 21 of the Arbitration and Conciliation Act. Stop. The notice under section 21 of the Arbitration and Conciliation Act has to be raised in terms of the arbitration clause as referred above. Stop. According to him, the said arbitration clause has provided the method or the manner of arbitration. Stop. The first of all, there should be an attempt to conciliate the dispute, and in the event of the failure of such conciliation, there shall be a mutual consultation in respect of nomination of the arbitrator. But such consultation did never take place. On the contrary, unilaterally, the petitioner has suggested name of one advocate as their advocate and nominated him as the arbitrator. Even the state arbitrator sent notice to the opposite parties to appear before him. Stop. According to Mr. Panigrahi, the Delhi High Court in Pro Building Systems Private Limited versus Ozone Overseas Private Limited, 2017 SCC Online DEL 7224 has laid down that for purpose of section 11 within C of the Act, without the notice under section 21 of the Act, a party seeking reference of the dispute to arbitration will be unable to demonstrate that there was a failure of one party to adhere to the procedure and accede to the request for appointment of an arbitrator. The trigger for the court's jurisdiction under section 11 of the Act is such failure by one party to respond. So Mr. Panigrahi, learned counsel, has robustly argued before this court that the said obligation was never discharged by the petitioner, and therefore this court should not entertain this petition as the prerequisites of demand under section 21 of the Arbitration and Conciliation Act has not been complied by the petitioner. Stop. Having appreciated the submission of the land council for the party, this court is of the view that the later dated 17/5/2022, annexation 9 to the petition clearly spelled out the dispute and also the demand. True, it is that in that letter there is no reference to section 21 of the Arbitration and Conciliation Act. But the immediately thereafter, within a period of 4 days, another letter in sequel to the letter dated 17/5/2022 was issued on 21/5/2022, annexure 10 to the writ petition, demanding appointing the arbitrator to adjudicate the dispute as referred in the earlier later stop. We should observe that the drawing of the notice under section 21 may not be happily worded, but even when the demand was placed very specifically by the letter dated 17/5/2022, and in sequel another notice was issued under section 21 of the Arbitration and Conciliation Act on 21/5/2022, annexure 10, there cannot be any amount of dispute that when the first phase of the demand was not fulfilled, the notice under section 21 was for the appointment of the arbitrator for adjudication of the dispute. In Arbitration Act, technicality definitely acquires a paramount position, but this kind of technology only frustrate the very object of the said. Technicality will frustrate the very object of the said act. Even the decision of the Delhi High Court in Alapro Building System Private Limited, what the court has held is that there should be a clear spelling out of the dispute and the compliance of section 21 of the Arbitration and the Conciliation Act 1996. When the unilateral nomination was made by the petitioners, the response of the opposite parties was that the petitioner cannot make unilateral petitioners cannot make the unilateral nomination, that should be consulted, but they did not propose any further name. Stop. If someone has proposed one name, though the word nominated may not have been there, it was the duty of the opposite parties to spell out the name of the arbitrator or to say that they will settle the matter within a specific period, in as much as the clause 15 also provide for the conciliation. The letters dated 17/5/2022 has brought an end to the conciliation process, and therefore, without any reservation, we should treat the letter dated 21/5/2022 as a notice under section 21 of the Arbitration and Conciliation Act 1996. As such, the court would not proceed to appoint an arbitrator for adjudication of the dispute as raised by the petitioner. Stop. It is also noted by this court that the dispute has been squarely admitted by the opposite parties. Stop. Having observed that, this court appoints Mr. Mishra. How many cases are with you presently?
Presently, I don't have, but I think it's my associate.
Oh, then avoid it. Mr. Mukherjee, you will also take this matter. This court appoint. Any objection to appoint?
No, I don't.
And do you have any objection to?
Malad, no, Malad, I'm sure, Malad. Anyone, never, Malad.
Appoint Mr. Gautam Mukherjee and his senior advocate as the arbitrator. Stop. The arbitrator shall proceed in terms of the provisions of the Arbitration and Conciliation Act for passing the award on after following the due process. Stop. Such arbitration will be held under the aegis of the High Court, Orissa High Court of Orissa Arbitration Center. Stop. We say another date. They will appear.
Same date, your lordship may give 15th September.
All right. The parties shall appear before the arbitrator on 15th September at 4:30 p.m. at the High Court of Orissa Arbitration Center at Cuttack. So the coordinator.
Malaj, here, Malaj, can I pray for 20th September, Malaj, subject to the arbitrator agreeing, Malaj? 15th already, Malaj,
some problem.
22nd.
22nd is all right then?
Yes, Malaj. Yes, Malaj. Grateful. So grateful.
22nd. So, the coordinator, High Court of Orissa Arbitration Center, shall make the necessary arrangement for the arbitration proceeding and provide the arbitration proceeding. A copy of this order, the supplied copy to Mr. Mukherjee and Senior Advocate and the coordinator, High Court of Orissa Arbitration Center. In terms of the above, this application stands allowed and disposed of.
Gratefully. Malaj, I'm so deeply obliged. Malaj, just one, Malaj, we just heard, Malaj, the response of the respondent, the date perhaps has to be, Malaj, 28 June 2022. Response,
right.
like it has gone down as May, perhaps.
I have not given the date.
Very well, Malaj. We heard May 2022, Malaj, it will be perhaps be June.
Your matter is 21-5.
Yes, Malaj, my letter is 21. Yes, correct. Grateful. Sorry.
Item number 4.
May I please, your lordship? And this matter was heard by your lordship on the 21st of July, when your lordships were inclined to appoint were about to appoint an arbitrator, when in terms of clause 25, which is at page 18, at page 19, the contract provides for constitution of a DRC, Dispute Redressal Committee. And my learned friend took time to ascertain whether a DRC has been constituted or not. I had made a statement that no DRC has been constituted.
Yes, admittedly it has not been constituted.
So agree to the arbitration. What to do?
My lord?
If DRC is not there, how the DRC will function?
Then your lordship may have.
No, because this non-availability is a good ground to refer the matter to the arbitrator.
Yes. But here is a case, my lord. Let's may see for a moment. Page 88, let's may see for a moment.
Page
88. This notice was given, this at 21 notice under Annexure 16.
Yes.
My lord, got it.
86.
Then here is a calculation. Page 86, it is started from 86. Last page is 88, my lord.
Yes.
That admitted pending dues 3,05,404.
Yes.
Their stand also taken, they are come to the High Court, against which they are going to Supreme Court. They are also in Supreme Court, they have admitted the same. Pendential Supreme Court who have paid the money, the admitted due is 3,05,404. Apart from this, the interest component they are charging to litigate 2 crore some odd and all these things.
Should we make any remark on this? Better you file your statement before the arbitrator.
Yes.
That is a better thing because we should not make any, because our
yes
duty is to only simply refer the matter.
Yes.
And only to look into the properly demand has been raised or there is an arbitration clause or not. Yes.
So may I suggest any district judge, Mr. MD Pradhan or any
difficulties? District judge, yes. We have a list of district judge.
Mr. Pradhan, one MD Murli Pradhan. He may be appointed. In my land, no objection, then MD Pradhan. Murli Pradhan is Murli Pradhan. Municipal, no.
There is a name of this first name is the Goyadhar Panda. Now the Durga Shankar Mishra, they are now all engaged as the permanent local chairman. So relieve them. Bijoy Ketan Mohanty, Pramod Kumar Jena, Pradeep Kumar Rai, Sanjay Kumar Panda, Chakradhar Kaur, Omiyo Kumar Sahu, and Premraj Bohidar, Miss Rekha Prasad, Basudev Panda, Ranjan Kumar Panda, and Murlidhar Pradhan. You are referring to Murlidhar Pradhan.
May I suggest, your lordship may appoint any senior counsel or the retired High Court judge?
Yes, I don't have a. High Court judge not necessarily a senior advocate or the
Senior advocate will be better.
yes, it will be better. Any of senior advocate.
Mr. Pangari?
Yes, sir. Hi.
Lakshmidhar Pangari. Heard Mr. Gautam Mukherjee, when a senior counsel is still by
JP Behra.
JP Behral and counsel for the petitioner. And Mr. P.K. Pari, when a Deputy Solicitor General of India is still by Mr. Bhukta.
Yes, DR Bhukta.
DR Bhukta, and it's CGC for the opposite parties. There is no controversy about the existence of the dispute. And about the arbitration clause. Under Section 21 of the Arbitration and Conciliation Act 1996 was given on 26/9/2022 by Annexure 16 to this petition. Both the council, appearing to the parties, have agreed that Mr. Lakshmidhar Pangari and his senior advocate can be appointed as the arbitrator for adjudicate the dispute. As agreed by the parties, this court appoints Mr. Lakshmidhar Pangari and his senior advocate as the arbitrator to adjudicate the dispute as raised in the notice dated 26/9/2022, Annexure 16 to this petition, and pass the appropriate awards in accordance with the Arbitration and Conciliation Act 1996. Stop. This arbitration will be carried on under the aegis of the Orissa High Court Mediation Center. So the coordinator, Orissa High Court Mediation Center, shall facilitate the arbitration proceeding. The coordinator shall, on consultation with the arbitrator, shall appoint the date of appearance, and thereafter the due process shall be followed, issuing notice for appearance before the arbitrator. So, for complying this direction, a copy of this order be supplied to the coordinator, High Court of Orissa Arbitration Center, forthwith. So, the rest is directed to send one copy of this order to Mr. Lakshmidhar Pangari and senior advocate for his knowledge.
I'm grateful, my lord, lordship is clarify out the section 21 issue. At least we have a great help for us in future.
Even the Delhi High Court decision is following the whole understanding of law.
Recently, I lost a case in Supreme Court. The same issue. They have not interfered, and Justice Sinha's order they have revoked. But there is a very confusing is coming. At least my lord is given a reasoning order. It will be great help.
All right.
Item number 5.
I appear on VC, my lord. My lord, this is an application under section 11 for appointment of an arbitrator arising out of an arbitration agreement.
Who is appearing for the
In this
opposite
case,
party?
my lord, I have instruction to appear on behalf of opposite party number 1 and 2. Some time may be given to take instruction. I'll file my wakalat now.
It's all right, but would you file any objection?
My lord.
Would you file any objection?
Yes, my lord. I'll take instruction.
All
I'll
right.
file.
Your good name, sir?
I'm T.N. Murthy.
At the request of Mr. A.K. Mishra, Land Council appearing for the opposite parties, when the matter will be listed on 1st of September 2023. Meanwhile, the opposite parties may file their objection if any. No further accommodation will be made. Mr. T.N. Murthy.
Yes, my lord.
Land
Yes,
Council has appeared for the petition. Okay, next.
Item number 6.
My lord, in this case, I am appearing from opposite party number 1 and 2. 3 is Gridco.
You are appearing for petitioner.
Yeah,
Your Lordship, I am on behalf of Mr. Shashwat Acharya as he is suffering from dengue. Your Lordship will file our Vakanalnama and will file our objection, Your Lordship. Kindly grant us 3 weeks' time.
At the request of the council, opposite party, suggestions. 1st of September is all right for you. Not paying for 1 and 2. 1st of September.
My lord, I am appearing in item number 5. In the item number 5.
I am in item 6, Your Lordship.
I was mentioning about
I thought in both the matters you are appearing. All right. That order has been passed already.
Yes.
So you are appearing for the opposite parties?
For all the opposite parties, Your Lordship. In item number 6, I am on behalf of Mr. Shashwat Acharya.
Your name?
My name is, Your Lordship, Jayesh Joshi. Jayesh Joshi.
Mr. Jayesh Ghosh. Joshi. Okay, Jayesh Joshi. Land Council appears on instruction of Mr. Shashwat Acharya, Council for the opposite parties, and prays for a short accommodation for filing the power and the objection with the petition. Dear States, let the matter be listed on the 1st of September. Okay, Lord, 2023. Mr. Amitabh Pradhan, Land Council appears for the petition.
Highly obliged, Your Lordship.
Item listed under special list, old matter item number 1, SA 137 of 1986.
Sishi Das. Anyone is appearing for the appellant?
I am for the respondent, Your Lordship.
Who is
State
appearing for the appellant? Is the page of page number? None appears for the appellant when the matter is taken up. Even there has been no mention for adjourning the matter. Mr. Panigrahi, D. Panigrahi. Land Council has appeared for the petition. And this appeal is pending since 1996. There was no initiative for the appellant. Yet the matter admitted over the years. Hence, this appeal stands dismissed for non-prosecution. We have dismissed for non-prosecution.
Item number 2.
None appears with the appellant when the matter is called out. So, his appeal has not been admitted over the years, and there had been no initiative for the appellant to get the appeal admitted. Are you appearing?
I am for the respondent 1 to 5.
Stop. Mr. Is good name say?
Abhijit Pal.
Mr. Abhijit Pal and counsel appears for the respondents. Stop. Dismiss this appeal. Even today there is no representation. Dismiss the appeal for non-prosecution.
Item number 3.
Appellant number 1 died, and he has been substituted by 1A, 1B, 1C, and 1D. Of them, 1A and 1B are dead, and 2 is also dead. Appellant number 2. I have to substitute.
All right. Heard Mr. B. Roth, learned counsel appearing for the appellant. You have filed any report of death before this court?
Pardon me, Lord?
Have you filed any report of death? No.
No, no.
Mr. Roth,
No.
learned counsel has stated that. Who died? You just repeat it.
Appellant number 1A and 1B have
One-
died.
one-
Substituted else.
Appellant number 1,
1A and 1B have died.
that substitute.
And appellant number 2 is also dead.
Appellant number 1A and 1B and.
2. Appellant number 2.
And
There are 2
appellant number
appellants.
2 have passed away in the pendency of this appeal. Mr. Roth and counsel prays for some accommodation for taking steps for substitution of the alerts. First is allowed, let the matter be listed on 15th of, yes, 15th of September 2023.
15th of
September. Meanwhile, the appropriate
Obliged.
steps shall be taken for substitution. No further accommodation for the same purpose shall be made. Yes.
Item number 4.
On behalf of Mr. Rahman, to which time may be granted, my he is ill,
You are
Mr. Rahman.
Huh?
Mr. Rahman is ill, my lord. He, on behalf of Mr. Rahman, I'm praying for 2 weeks time.
Mr. Rahman. It has been stated at the bar that Mr. E. Rahman, non-counsel appearing with the appellant is unwell today. Let the matter be listed on 1st of September 2023. Stop. All right.
Item number 5.
Item 5, I am for the appellant, your lordship. I'm for the appellant, your lordship. In 2002, there was a direction for appellant number 1 had died, and I have to take steps, your lordship. I had written letters to opposite appellant number 2, but no response, your lordship. One more chance may be given and let it come on first.
Let me request to Mr. B. Panigay and counsel appearing to the appellants. Let the matter be listed on 1st of September 2023. As Mr. Panigay has reported death of appellant number 1. The steps for substitution shall invariably be taken. Substitution of the others invariably taken by the next day. No further accommodation be made for the said purpose.
Grateful.
Item number 6.
May I please your lordships?
Yes.
Here, my lord, the
appeal has been filed against the reversing judgment, my lord. The fact, the lower court, what has happened, my lord? The appellants were defendants in the lower court. In the lower court, the plaintiff has filed the suit that he has right title interest and for recovery of possession.
Yes.
The trial court found that he has no right title and interest, and he has also no possession. My lord may come to para 15 of the lower court judgment. With due respect, para 15.
Have you complied the subsection 4 of section 100 of the CPC while preparing the memorandum of appeal?
My lord, I have framed the substantial question of law.
Where?
Your lordship may see my ground number 1 and 2, the substantial question of law. Ground number 1, your lordship may see.
Yes.
The substantial subpara. Ground number 1 at page 4 of the appeal memo.
Page 6.
Page 4 of the appeal memo.
Page 6, I don't know 6.
Subsequently, yes, subsequently page 5 has consolidated petition filed, page 5. My lord, I'm sorry, page 5. Page 5, consolidated.
I have only one memorandum of appeal.
Yeah. Grounds para 1, I'm sorry, my lord, grounds para 1. That
This
is
is the, for that the decision of the, this is the ground 1.
No, my lord,
Are you here in the, what is the case number? You are just.
Second appeal 57 of 87.
I'm on the same case.
Yes, my lord, your lordship may. Yes, my lord.
There are only.
The appeal memo, first it is facts 1, 2, 3,
Right.
4, 5. Then being aggrieved grounds. Being aggrieved grounds. So lordship got it. Being after the being aggrieved, there are grounds.
Thereafter, amongst other grounds.
Yes.
One, for that the decision of the learned courts below is not declaring the plaintiff's title over the suit are contrary to law and without jurisdiction. Cannot be a substantial question of law.
No, my lord, I have framed the substantial question of law. It has been framed. Lordship may see my.
I'm concerned with my records in the show here. The physical.
I will verify, my lord, because in my ground number 1, I have framed this question. The substantial question of the RIGS for consideration as to whether the suit is hit by section 39 of the OE Act.
Because I don't find any amendment has been carried out also. From the physical copy.
My lord.
No, him, in council show, because I have got the scanned copy.
I filed it. Yes, ma'am. Yes. Below that grounds, there is a substantial question of the grounds. Lordship may see that. Below the grounds, there is a substantial question of law I have framed. Grounds 1, subparagraph, the substantial question of law. I am sorry, ma'am. Your lordship, the grounds 1, subparagraph is the substantial question of law.
How that can be? Because my brief, it is not there.
My lord. But how? My lord.
No. Oh.
I'm sorry, my lord. I'm sorry.
Okay. You amended the memorandum of appeal.
Yes. Because there is some amended means there is some consolidated cost title I have to file. Therefore, it has been elongated and it is there, man.
No, even you have changed the grounds also. And by which order that was done, I'm not getting any such order.
No, but 2 grounds were there initially. Those 2 grounds are continuing. Initially, when it was filed in 23-287, these 2 grounds were there along with substantial question of law. That has been reiterated in these grounds only. Nothing more I have added.
No, but just to show the old one. It is there. It's on the screen. On the screen to show. That was not there in your original the memorandum of appeal. This ground.
Yes.
You are saying your two grounds are similar to the earlier grounds.
My lord,
This
two
is not
grounds,
the
sir.
case. This is
Yes.
not the case.
My lords,
Whether the court has permitted you to amend this grounds. Or at the time of filing the consolidated petition, you have added this page. What is the situation?
no, my lord, original grounds was there. I have the
I am
original.
showing, I am reading the original
I'm-
grounds from my record. Show this old unconsolidated.
I'm sorry, my lord, there's some.
No, that will be, that cannot be
No,
entertained
no,
by
if
the court
there's
unless there is any order.
Yes, ma'am. I have not, but to my record, I am sorry, my lord. To my record, I have not amended.
Just show this come to the page 2.
This is a cross objection. Just a minute. Just a minute, just a minute. Your lordship, what your lordship is seeing, that is a cross objection. The cross objection is there. There is a cross objection in which your lordship is seeing the different grounds. Below that, there is the original plaint. Just a minute. That is the cross objection under 41 rule 7. Below that, original is there. Yes. No, is there. Below that, second appeal 57, I am just showing the original is here.
You're right, you're right.
Am I clear, man?
That is how it can be done. Why the
That should be.
cross-examination is put in the. This
No.
is absolutely unscientific method. Yes.
I'm sorry, my friend. That is cross objection.
Who is appearing to the respondent for cross objection?
Nobody is there.
First of all, you tell me whether the appeal has been admitted.
Yes, appeal has been admitted here. First order is there on grounds number 1 and 2. That is there. I have seen the order.
There is nothing scam. Show this thing.
Appeal has been admitted. First order, I think the 1 and 2, it has been admitted.
Yes. Can you just recall the order date? Order date by which the city was admitted and substantial question?
First date. That is there in the order sheet. Appeal will be heard on 1 and 2. It is from the beginning, I think.
Now, because any order has to be passed in reference to that order, now. Substantial question, just please help me.
Yes. I'm just giving. Dual. I'm just helping. First, 23,387. My lord, Messi.
So grounds 1 and 2.
My lord. Has been admitted.
All right.
Say,
Yes.
May I pray one thing, my lord? It's a case of 87. I am ready with the case, but some of the parties were aged that time 70, 30 years appellant and respondent. Your lordship may give some time. I'll verify they're dead or not, because I will argue that you are against a dead person. I'll verify that. Your lordship may see.
You are Mr. Mishra.
Yes, A.K. Mishra. A.K. Mishra. I'm A.K. Mishra.
Earlier counsel was S.S. Mishra.
No, he was my late father.
All right.
Yes, please. I'm A.K. Mishra.
Heard Mr. A.K. Mishra, learned counsel in part, let the matter be listed.
Give some time, I'll verify.
2023 for continuation of hearing. Stop. Please. By the order dated 23/3/1987, the substantial questions of law was raised. So, the substantial questions of law as involved in this appeal are as enunciated in the grounds 1 and 2 of the November appeal. Just I'm extracting the order so that it can be.
My lord, oblige, my lord, oblige.
It's old record.
My lords,
So 1st September it will come. In the meantime, you take information.
my lords.
Item number 7.
My
I'm for the respondent.
Yes.
I am for the respondent.
Nobody is there for the petitioner.
Respondent number 1 is dead long since. He was the plaintiff.
None appears for the appellate when the matter is taken up. However, Mr.
Ramakant.
Your name is there.
Yes.
This is item number 7, no?
Item number 7, I am there.
You are Mr. Mohanty.
R.K. Mohan.
R.K. Mohanty. Front counsel appears for the respondent. You are for appearing for all the respondents?
No, I was appearing for all the respondents. Only respondent number 1 is the plaintiff. He is dead.
Okay. The respondents number 2 to 5. Mr. Mohanty has stated that when, can you just tentatively give the year when death occurred?
Not, I have a noting here 25/11, but I have not.
Not the
noted
year is not there.
Not there, sir.
So Mr. Mohanty and counsel has.
Long back,
reported,
Lord.
reported death of the respondent number 1 long back. But the appellant has not taken the steps for. The appellant has taken some steps for substitution, I think. The appellant had taken steps for the substitution of the elders of the respondent number 1. But there is no representation from the elders of the respondent number 1. In this situation, this evidence is dismissed for non-prosecution. It is dismissed for non-prosecution.
Item number 8.
State is the appellant, your lordship.
Who is appearing for the state?
I am for the state.
You are for the state, okay.
Your lordship, it has come after 88, your lordship. So I urge my learned friend, if to provide any instructions, whether substitution now, if any nature has to be filed by me, because it is easier for him to file.
Do you have any communication from the respondents?
That is some timeline,
7 days time. There's a matter.
No.
No, 1st of September it will come. When the matter will be 1st of September 2023. And you are on record.
No, I'm appearing on behalf of Mr. F2
Okay. Your name, I forgot your name. On instruction of Mr. S.K. Paril and Senior Counsel. So Mr. D. Paril and Counsel is appeared for the appellant. Both the counsel appearing for the appellant and the respondent shall take instruction whether the cause still survives for adjudication, still survives or not.
Brief. Item 9.
8, there are 2 matters.
Same parties.
Same.
Grateful.
Similar order. Parties are also same.
Item 9.
Yes, who is appearing to the appellant? it was admitted on 21/7/1987. On framing the substantial question of law. Today, when the matter is taken up, none appears for the appellant. Are you appearing, Mr. Panigrahi?
Yes, Your Lordship, for the state. Your Lordship.
Mr. Panigrahi and counsel appears for the respondents number 1 and 2. There is no representation for the respondent number 3. This appeal stands dismissed for non-prosecution. 10.
Item number 10.
Did you file the application for the substitution in the year 2000?
Case number 171 of 2006.
Yes.
Part A, B, and C.
How this abatement petition has been filed early? IA 173 of 2000. This is an abatement, setting aside the abatement petition. It was filed early. And then there is also a 2005, there is an application for condemnation of delay.
2006. 2006. First petition is 171 of 2006. Second is 172 of 2006 and
okay.
3 petitions have filed.
All right. But because in our edited page, it is coming and one application was in 2000, another application was 2005, but from records we find all were filed in 2006. Yes.
All were filed in 2006.
Sole appellant died.
Sole appellant died.
And what? Who is appearing for the respondent? Do you have any objection?
No copy has been sought on me.
All right, 1st of September is a survey copy. This 1st September. We pass the order. This case number 172 of 2005, no 2006. Let the matter be listed on 1st September 2023. Yes, sir. What is the item number? N.K. Sahul for the appellant. Mr. N.K. Sahul and counsel has submitted that he is representing the legal representative of the appellant. So this is the application under 5 of the Limitation Act for following the delay. Yeah, Mr. Mohanty.
No, G for it.
You are there.
Power is not there. I'm appearing on behalf of the state.
Mr. G. Porida. Learned counsel appears on instruction of Mr. S.P. Mishra and a senior counsel. For the opposite party. There are several respondents.
Yes, sir. 4 numbers. I have 1 to 4. Rest also
You are appearing for opposite party number 1 to 4.
Yes, sir.
Opposite parties number 1 to 4.
They are the contesting the.
But here the only 3 respondents are there. Just check out how many respondents are there. This is the appeal, but application there are all respondents were opposite parties number 1, 2, and 4. So, copies of the miscellaneous application shall be supplied to Mr. Puri by tomorrow. All right. It's already through the no? They give, in other matters, time will be given and it will continue. All it was the 25th. The 25th, there will be a problem. Difference will be there. Oh, no, then first September. Now we just Sahu. Other matters will be taken up on 1st of September. All other matters which could not be raised by today.
To which time may kindly be granted for issuance of requisites for press notification. Yes, Miller.
Order was passed.
On 18/7/2018.
What you are doing till now?
Lord, after it has not come to our knowledge that whether that notice has been returned, the requisites you have filed, it has been returned.
No,
Then
in your presence,
yes, my lord.
the order was passed to file requisites.
No, my lord, in my absence, it has passed.
And you are not supposed to keep track of the case.
Yes, my lord, I'm sorry for that, but after that, corona has come and
How many cases your wife has instituted against you in the meantime? What is the status of your wife? What he has done? You have filed
No,
this?
yes, my lord, I'm saying she has gone for the childbirth at her parents. After that, no dispute, nothing.
No, I'm not telling about that. This is a divorce petition
Yes,
which
ma'am.
has been dismissed,
Yes, ma'am.
against which you have filed this matter.
Yes, ma'am.
Right?
Yes, ma'am.
So how many cases your wife has instituted against you?
Nothing. She has not done anything. When after the childbirth, I had been to see the baby at my in-laws' house with golden chain, dresses, and all these things. It was thrown to the street without any dispute. There is no dispute. It is most unfortunate case. There is no dispute. Neither she has demanded nor done any case, and
Has she not filed any maintenance proceeding against you?
and now he is also depositing money for his son. That the son is going after completion of class 10. He is depositing the money in his name, the petitioner. But it has not been.
For a petition for restoration. Already been dismissed. The petition for restoration, they're so careless. Your matter appeal was once dismissed for
Yes,
non-prosecution.
Yes, Miller.
Then you have filed an application for restoration.
Yes, Miller.
You were asked to take requisites, you did not file it.
Yes, Miller. In the lower court also, she refused to receive the notice. Even special messenger was sent.
All
This
I
time,
get-
last chance may kindly be
It
given.
starts by 25th of August.
Obliged.
at the request of Ms. Hiron Raut, counsel appearing for the applicant, let the matter be listed on 25th of August 2023. In the meanwhile, the order dated 18/7/2018 shall be complied. It made absolutely clear if the said order is not complied by the next date, will be compelled to pass an order for non-prosecution. Next.
Item number 2.
Page 3 of my application. Page 3 of my application, it was ordered that postal requisite shall be filed within a week, failing in which the writ petition shall stand dismissed without further reference to the bench. On filing of the requisite within the time stipulated, official proceed accordingly. But unfortunately, that postal requisite was not filed. It is the case of the petitioner that the conducting council has left the practice, regular practice at Kotak. He is residing at Bhubaneswar.
Objection.
Here, no, Lord Jagannath is there. Notice has to go.
That is notice will go, but you don't have any objection.
We restored the.
This petition has been filed after 3 years.
Limitation petition is also there, my lord.
That is Mr. Tripathi is saying that the council was appearing for this person. He has retired from the practice.
That is one part, but client has also some obligation towards his brief. He never contacted the lawyer. This main petition arises out of OEA proceeding.
Matter was once decided by the Honorable Court, and that order was also confirmed before the Honorable Supreme Court, which is reflected in page 11 of my writ application. Page 11.
Order was passed on 8/1/2016.
See,
1 week time was granted to you to file postal requisites.
Negligent
And
is
we
there,
are in
my lord.
23
Yes.
August.
Negligent is there, my lord.
What is the subject matter?
Subject matter is the my father was the permanent leaseholder. A permanent lease deed is there of the year 1950. The property belonged to a matha. Though the Lord Jagannath is the deity of that matha, but at Puri. But the authority held that the property belonged to Jagannath Puri according to the Jagannath Temple Act. But that was disputed. Matter was also once decided by this Honorable Court. It is a reported decision. My lord. Thereafter, the matter was remanded. A complicated question is also there, my lord. Which is adjudicated. My lord, this Chiranjit Lal Potwari was the petitioner. He is the father of the present petitioner, my lord. A matter was agitated there in respect of these properties.
No, this law has been decided. The 5 years is the maximum time. Unless the lease is renewed by the express provision, it will be treated as not
permanent lease deed. That was the permanent lease deed. That is the not a lease for the certain period.
No, just see, no lease for term exceeding 5 years of any immovable property belonging to any specific endowment attached to the many mort or temple shall be valid or operative unless it is necessary. So the 5 years by the law has been declared by the Supreme Court the maximum period of the lease. So what is your case? Your decision is completely against you.
Lastly, kindly take a glance to the. For this reason already indicated, we also quash the impugned order under the Act and require the Commissioner to redispose of the matter in law, and while disposing the proceeding, he shall provide full opportunity before him to place necessary materials. So ultimately, my case was allowed and the impugned order was quashed. Matter was remanded. Thereafter, case initiated under section 25 of the which Act was dropped. My humble prayer, let the writ application be restored, then matter be heard.
You just by dosti, you take service in the Jagannath Mott. So I'm issuing notice, this limitation, but you by dosti, 1st of this September, this will come.
Yes, ma'am.
The State Council. And also come prepared on 1st September. The original matter may be heard on merit.
Yes.
Because we look into the merit.
Yes.
This condoning the delay.
The delay has been pointed out to be, what is the delay? The period of delay is
1,400 days. That was the reason why we just a meritless case. Why we condone the delay? That will be the issue.
So the State Council accept notice as 2, 3, 4 and 5.
That is why I am Temple by Dosti.
Right.
This application 194 of 2020. It has been stated by Mr. A.K. Tripathi, Current Counsel, appearing to the applicant, that the certified copy of the order What is the date of the order that you are challenging?
Date of the order was 8/1/2016,
Is
para 2.
order dated 8/1/2016. As passed in WPC number 17409. Could not be filed. Still, however, a photocopy of the said order could not be filed. Not even a photocopy of the said order is available with the dispensation application. As the record of WPC number 14709 of 2006 is a part of this, has been produced in this application, along with the application, we dispense the requirement of the filing of the certificate copy on condition that by 1st of September,
My lord,
certified copy
my
shall.
lord, it will be 4th September or 8th September, kindly.
No, 1st September. By the 1st September, certified copy of the said order shall be filed by 1st September. Accordingly, this application stands allowed and disposed of. Then I number 348 of 2019, there is an application under section 5 of the Limitation Act. As the application for restoration could not be filed within 30 days from the date of the order by which the WPC number 14709 of 2006 was dismissed for non-prosecution. So there is a delay of 1,400 days according to the stamp report. Issue notice by the aforementioned delay shall not be condoned or any other order or order shall not be passed. Notice is made returnable on 1st of September 2023. Since Mr. P.K. Mudoli, London Additional Government Advocate, appears and gives notice for the opposite parties number 225, no formal notice is called for in respect of these opposite parties. The petitioner shall take the service of notice by Dusti on the opposite party number 1. Dusti service shall be completed by 25th of August 2023 and by 27th of August, 28th of August, the affidavit affirming that the Dosti service has been done. Such affidavit shall be filed by an authorized person of the applicant. It is made absolutely clear this if the service is not completed as term of our order, we will not grant any further adjournment for this purpose. Mr. Muduli, that come prepared also because it is 1,400 days delay. At the time of consideration of this limitation, we may decide the matter also.
The copy of the writ petition be served. The copy of the writ petition be served.
You serve the copy of the writ
Yes,
petition.
yes, I am sorry.
Mr. Tripathi, London Council should supply the one set of all the miscellaneous applications along with the writ petition by tomorrow. Supply the copies by tomorrow.
Yes.
Ouch. Fine.
30/6/2023.
Yes.
I have already deposited, I have already complied with the order, deposited the entire amount that is in the registry, Your Lordship. I pray that let it be restored so that the matter can be heard any day, Your Lordship. Writ petition can be heard any day.
Thank you, Your Lordship. I am appearing for the workmen in the CMAPL on the date of order, that is on 30/6/2023. Lordship is stating the order that 30/6/2023, Mr. Lakshmi Das advocate and to appearance for a 9 of the workmen, which Patna at an expenditure for appointment 12. That in terms of the impugned hour, each of the workmen was to be paid ₹2 lakh as a compensation in lieu of reinstatement. The award is made way back in 2011, nearly 12 years ago. As a condition for the restoration, this year-old matter, the court directed that the appellant managed to deposit this court sum of ₹24 lakh.
They have deposited that amount.
Yes, Your Lord.
I have entered appearance on 30/6/2023. I have not completed my say that the order has been. Three anomalies are there in this order.
All right.
First paragraph.
We are considering a very limited question whether we will restore their case or not. You will be getting the opportunity to make your submission on merit.
2 minutes.
Yes.
Here they are not the past order. In terms of the impugned award, each of the workmen was to be paid ₹22 lakhs in lieu of reinstatement. That is not the award. First of all, you want to have a glance to the award. That is not the award at all.
What is the award?
Award is impugned order of the award that I am not given the copy. In 2012, award in 2011, 2012, credit file, they order taken. The requisites were to file within 3 days. No requisites filed for notice to workmen. Matter kept pending for about 12 years. When the matter listed after admission in 2022 after the COVID period, said that file taken over by the management. The Lordship's past order in view of the statement that file taken on the management, it will be dismissed for non-prosecution. Thereafter, Mr. Mishra appearing that I am appearing in the case in 2016. For 2016, 2022, no step taken for notice to workmen. For 12 years, they still sat over the matter, no notice, nothing. Matter of the year 1988, 35 years, not a single file paid to the workman. Order stated, our stated that termination illegal without notice. Reinstatement, they are entitled for reinstatement. This is the order and the award reading, the operative portion. Since the termination of the service of the district workman is not justified and legal, they are liable to be reinstated in service if they have not attained
That
the age
order has
of
been challenged. That order has been challenged here. So what is the limited ground today that this order will not bind you, will observe that whatever this para 1 of this order dated 36/2020-23 has been observed, that will not bind you because it was not passed after hearing you. But let us restore the.
No, I'm just three things are there. One thing, why I'm telling you. That first thing, that the order stated that in view of reinstatement, our part, this is not correct.
What I am telling, try to understand that. I am telling whatever it has been ordered reflected, that is without hearing you. We are reopening this observation and we'll hear on the merit, and whatever the outcome of the merit, that will be decided by them.
Yes.
For
I
that,
understand that.
Yes.
7 days time is given, I will file a petition. And I will pray that the particular their deposit maybe a portion among the paying workmen as a cost, which we usually do, not kept deposit in court. We have entitled crores of rupees for 2012, forget about 23 years of service 1980, 2011 hour, after hour, entitled for reinstatement. No reinstatement given, no notice given 12 years. If daily basis, one workman is to get rupees 1,000 a day, 30,000 per month. Year per annum, 3,60,000. And 12 years, they have lost about 40 to 50,000. One workman, 10 workmen, crores of rupees they have lost. They have not given any statement. And every workman have 10 to 15 years service left.
No, but this observation is incorrect according to you.
Yeah,
2 lakhs is compensation in lieu of reinstatement. Is it an incorrect observation?
Whatever the amount they have deposited, it was distributed among workmen and work. And thereafter, they find
We understand things, but what you are saying that 1,000 daily wage, making it this 30,000 per month, the lakhs in the things. But the order of the labor tribunal was that they will get 2 lakhs in lieu of this.
Not in lieu of Indian statement, that's not the award. That
Where is their judgment? Give the file.
Judgment in the writ petition, page 57 of the impugn, Annex 7. Writ petition, I remember. I don't have copies. I am not given because I have not received copies till that. Annex 7, I remember.
This is the notification, gazette notification.
Page 47.
The word follows thereof.
Page 44. The Lordship may come to page 56 in my brief, if it is correct here. That para 13, 1-3.
Internal page 11, para 13. Plus parage.
That is the amount of compensation awarded.
So this observation passed in this order is wrong order. Yes. This observation is not correct. Because it is not in lieu of Mr. Mishra.
My lord.
It is not in lieu of, because they said they will not.
In lieu of back wages.
In lieu of back wages only.
Yes, yes, Lord. Yes. It was a composite amount given by the tribunal, which I have also challenged, Your Lordship. And that reinstatement word may not be correct, Your Lordship. Your Lordship is correct.
You filed this objection by 1st of September? 1st of September.
Well, in the meantime, the number 4 has died. I got information from
Mr. Mishra, that opposite party number 4 has passed away.
4, Your Lordship. No, 3 to 11 he has appeared, Your Lordship. 4 has died. But he has appeared for 3 to 11, Your Lordship, as it appears from the last order sheet, Your Lordship. 3 to 11 it is stated, Your Lordship. I don't know.
You are appearing for whom?
He is for Mr. Biswal is for OP number 12. One workman.
Now, Mr. Rajguru appearing for a 1 and 2.
No, yes. He is Central Government Council.
And Mr. Biswal, you are appearing for whom?
OP number 12. Single workman, number 12. And Mr. Das is appearing from 3 to 11.
3 to 11.
Yes.
So according to you, 12 died.
12, 4 died. No. 12 is appearing here also. Vishwal is appearing.
Do you have any idea whether
happening for 3 to
11.
3 to 11, it is noted, Your Lordship.
But 4 is expired.
interception that is why it is
All right, at the request of Mr. Lakshmidhar Das and Council is appearing with the opposite parties number 3 to 11. Let the matter be listed on 1st of September 2023. In the meanwhile, this opposite party may file their objection, if any. Mr. B.S. Raiguru, CGP has appeared for opposite parties number 1 and 2. And Mr. S.M. Bisol and Council is appeared for opposite party number 12. Would you like to file any objection? No. You'll file. You will not file anything. The opposite party number 12 also may file the objection, if any, against the application for restoration of the writ petition being WPC number 5822/12.
Yes.
It was dismissed by the order
11/7/2022.
11/7/2022.
7/2022.
11 July 2020.
Yes.
For non-prosecution. Mr. M.K. Mishra and a senior counsel. Is it by A. Mishra or so?
A. Mishra. Yes, yes. Anshuman Mishra.
A. Mishra and a counsel appears for the applicant. All right, 1st of September it will come. On that day, raise the prayer for release of the money. All right, you file the first objection then. And Mr. Mishra, you take instruction. We are going to release the money.
So, my lords, my humble submission is there. Your Lordship may hear the matter at all, Your Lordship, completely.
The matter, consider the condition of the workers also.
Yes, Your Lordship, but these 2 lakhs which I am saying, it is a matter of closure of the establishment here, and they refuse to go.
We'll consider all the matter. Let them get 2 lakhs each. After that, okay.
I have objection to my that because I will also find. What part? It is a pure case, Your Lordship. It is a pure case, Your Lordship. This is a matter which I have not been hard. And what my learned friends are saying,
but rest assured the matter will not be remitted back.
No, I'm not saying.
We'll decide here. Yes.
I am not in favor of remittance also. Decision, Your Lordship.
For orders, item number 1. Yes, 1, 2, and 3 are identical matters, my lords. Your Lordship, for the sake of convenience, may kindly take off item number 2, because in item number 2, judgment is delivered by Your Lordship, my lords. Dealing with the 2 questions, my lords. Yes, I will take for a file Your Lordship's attention to, my lords, the operative point, page 7. Internal page 7, paragraph 4.
Item number 1.
Item number 1, 2, millers. 2 is the judgment is
all right.
Delivered in that matter. Page 7, paragraph 4.
Yes.
Yes. Millers, accordingly, question number 1 is answered in negative. That is in favor of the assessee and against the department. The deduction as claimed by the assessee is allowed. The demand will now be recalculated by the AO by giving appeal effect to the above order. This is the direction. Next, your lordship may kindly turn to the question number 2, which your lordship has dealt in, and the findings is at page,
last paragraph, but 1.
Yes.
Para 7.
Para 7, page 9. Yes. In that view of the matter, question number 2 is answered in the negative, that is in favor of the assessee against the department, and it is held that after an assessee will be entitled to benefit of deduction under section 80p4 of the Act, since it is a cooperative society involved in business of banking. It is open to the assessee after appeal effect is given on the basis of the present order to apply for refund in accordance with law. These are the findings, and in the next writ petition, item number 312682, your lordship have said that both the writ petitions shall be abided by the order passed as per ITA 113. If your lordship will turn to page 12.
So in item number 2, your IA is for giving a...
Yes, because your lordship has not stipulated, given time stipulation, 2 things are to be done. So far as question number 1 is concerned, your lordship directed that the liability to be recalculated as per lordship direction 1. So it needs recalculation to compute the liability and to grant refund if it is at all generated out of such recalculation. Question number 2, already your lordship answered. Now appeal effect is to given, and your lordship also made it clear. If you after this recomputation, you make an application for refund, that will be that. Your lordship are not given a timeline. Now I have been approaching, your lordship will find several applications I have annexed to this IA lords. They are not responding, lords. My humble prayer is that let them recalculate so far as question number 1 issue is concerned. So question number 2, your lordship may kindly give a deadline so that let them recalculate, recompute, and grant me refund, whatever refund. That is the only prayer.
2 is dependent on the calculation is 1.
One calculation, 2 to give effect to your lordship's order.
Your lordship, item 1, 2, 3, I am appearing on behalf of Mr. Satpal lordship. In all 3 items, we have to take instruction whether department has preferred appeal for Honorable Supreme Court or not.
What instruction?
We are taking up the matter on 25th August to take the information. We are granting and no further chance will be given because the issue is very simple.
Correct.
All right. At the request, you are there.
No,
Mr. Shatapathy, you are not there.
He's HON'BLE lordship. I am appearing on his.
No, what is your good name?
Devasis Hajra. Devasis Hajra.
Devasis Sarangi.
Devasis Hajra.
Oh, Devasis Hajra. No, he is appearing to T.K. Shatapathy. Mr. Devasis Hajra and counsel appearing on instruction of Mr. T.K. Shatapathy and senior training counsel in contracts has requested for a short accommodation for taking instruction. Stop. First tense allowed. Let the matter be listed on 25th August 2023. All the matters 25th August.
I don't know.
Mr. Sarangi, you are appearing in all the matters.
Both are together we have appeared.
Is 3 only?
1, 2, and 3. Item number 4.
My lords, item 4, I appear for the petitioner, my lords. This is an application for recall. Now, what had happened, my lords, is this company had gone through CIRP under the IBC 2016, my lords. Now, the demand that was challenged in this writ petition has also been challenged in a subsequent writ petition.
Yes.
Because it forms part of a larger demand by the department, my lords. Now, my lords, what has happened is, in all fairness, my lords, I must say, my lords, on 4th of January, lordships may see the order dated 4th January 2023, my lords.
On the which ground this order you like to be recalled?
My lords, there was a liberty granted to me, my lords, in the 4th of January order to file a fresh application in case any cause of action survives. I bow down, my lords. I bow down, my lords. The only reason why I'm agitating this application for recall is because it'll avoid the entire process of filing a fresh petition, etc.
No, we are not concerned because we are bound by the law.
My lords.
Recalls, the word that you have brought is a substitute of the review. Otherwise, how the court can recall the order? Only this is the means of the review, the court can recall the order.
We were conscious actually when a new company has taken over the older company. The new company has to come on record and it has to file its own cause.
My lords, it's the same company that continues, only the management has changed.
No, different company, corporate.
No, my lords, it's the same company.
No.
My lords, I can...
Bhushan is something different from Tata Steel.
My lords, Tata Steel is because of a change in name, my lords.
No, it can't be.
The company, my lords.
Is it change of name clause before the ROC?
There has been a change in name. There has been a change in name.
Only change of name.
Before the ROC, there's only been a change in name, my lords. The ROC cannot certify that the management has changed hands. The NCLT certifies that, and the same company continues.
IBC,
only the management changes.
In IBC, you have purchased that company.
Yes, my lords.
Then
the management changes, but the company continues.
It is a new company.
No, my lords. The same company continues. With the deepest respect, my lords. The same company continues. It is the same company. It is, your lordships may take my submissions on record.
It has been mentioned in the IA, Tata Steel Limited is the applicant and Bhushan Steel Limited is the petitioner.
Lordships, there are several matters of this kind.
For the purchase.
Steel was the petitioner originally, and Tata Steel has been substituted, and not because it's a different company, my lords. Initially, let me tell you, lordship, the chain of events was.
Brother Ramon is pointing out is altogether a different aspect.
Yes, my lords. If your lordships like, I can address we can address your lordships on this issue.
Now, this is all right that we can grant you the accommodation. That's not the issue. But what the point he has raised.
Yes,
that it is a clear transfer by demolishing the corporate identity of the Bhushan Steel. So he has become a new owner.
My lords, the idea of insolvency is that the company continues as a going concern. Yes. So therefore, the company never ceases to exist on the books of the ROC, my lords.
Statement of objection reason says in IBC,
yes,
the new company starts from its own way in clean slate.
It starts with a clean slate, my lords. Deeply obliged, my lords.
Inherit the
new management starts with a clean slate, but it's the same company that continues. The corporate identity of the company does not change.
Maybe. But that is why
so
very conscious we have asked you to file a fresh petition. We have not touched any merit also. So what is the harm in filing a fresh petition? We will entertain, if at all it is entertainable.
Your lordships, I am only on the point that your lordships can also sort this issue out by.
But there is another greater issue is that how can we recall? Where is our jurisdiction?
Your lordships has the inherent power to recall.
Sorry. That I do not surprise. Anybody can subscribe it. I don't surprise. That will invite only the chaos in the system, nothing else.
My lords, if I may just submit, my lords, what has happened in this matter. Now,
you have to show our jurisdiction first, that we can exercise that jurisdiction because we have passed the final order. You want us to recall the final order. Only it is possible under the jurisdiction of review. Something patent illegality has been done while passing the order. Otherwise, we cannot recall any order at our discretion also, that we will recall this order.
Lordships always has plenary jurisdiction, but I'll satisfy your lordships on this issue.
Plenary jurisdiction or not for the abuse the process. That is not there. That on the fall of head, we will be reacting. That's not done.
Your lordships may fix it, we'll satisfy.
You are sure this, what is the difference between the recall and review? And if you say it is a recall, we'll treat it as the review. And all the rigors of the review jurisdiction will be applied in your case. In that case, you are going to suffer, nothing else. So what my brother is pointing out, you withdraw this petition and file a fresh petition.
Lordships,
Because the liberty was granted, there is no bottleneck. Take the advantage of that liberty.
Lordships may keep it to next week, we'll take instructions.
Already we are fixing it on 25th again. List on 25th at the request of citizens. So on the next day, there shall be no adjournment. Mr. Chipamka, are you appearing?
Yes, yes. I file counter on this. I.
All right. Mr. Aris Chipamka and the council appearing for the opposite parties. To file the counter affidavit today in court. The same is taken on for the court.
We will receive a copy.
You have received the copy?
Yes.
Copy has been supplied to the council for the applicants.
Item number 5.
Great.
This is registration. Within time, 27/10/2000.
Private parties are there.
Your lordship.
Third, MS S. Mohanty, Land Council, appearing for the applicant. This is an application for restoration of WA number 453 of 2018, which was dismissed for non-prosecution by the order dated 27/10/2022. The issue notice returnable on 21st of September 2023. Steps for service on the opposite parties shall be taken by the applicant.
Your lordship issued notice to private opposite party. Your lordship issued notice to private opposite party. And in read appeal, that respondent already appear. If your lordship permits me, I'll serve copy.
Problem is that if they refuse, then what will happen? That is what I'm thinking of. I'm making the alternative also. Issue notice, citizens, the registered posted will be within 5 working days. So, but if the council earlier appearing for those opposite parties, accept notice, no formal steps will be required.
Yes.
That I'm giving, otherwise it will
Then
be
your
5 days.
lordship, your lordship.
5 days, 5 days.
5 days. Within 5 days, you try.
All right, make it until we can wait until 22nd of September.
Your lordship.
Item number 6.
Yes, Mr. Patnaik.
With due apology, my lord. It is the matter on 27/10/2022, my lord. On that date, I am facing acute pain in my teeth, my lord, so that I cannot come to court. There is no notification regarding boycott of the court. So why will you abstain from not come to the court? Due to this personal problem, I cannot come to the court, my lord. So let me.
But your reasoning is something else.
Thinking that I have participated in that strike.
Have you gone through the order dated 1st of February 2023?
Madam,
Para 1
I have always gone through it.
is a
A
condition.
small setup of lawyers are doing this type of strike.
No, on that we are not going. It is says the court is not prepared to accept the explanation offered by the application, particularly since what happened on 27th October 2022 was an illegal call for boycott of the court by one small section of High Court Bar Association
unless the lawyer is prepared to come clean on the real reason for avoiding appearing in this court and is prepared to tender a sincere apology, this court is not prepared to consider this application.
I am tendering my sincere apology for my lords, because I am tendering my unconditional apology.
Where?
Before this court, my lord.
Not oral. We have not asked. The court by record asked you to tender the apology. That should be in record. If you want to file it.
I filed it.
You file it? You have filed it.
Today I filed it. In course of the day I filed it, no problem.
Can you do it in the course of the day? Otherwise,
It is
Today I
already
do.
filed. It is already filed. Counter suit with close.
Just memo, I have a.
all right, we are fixing the matter on 25th. In the meanwhile, you file it.
Published.
At the request of Mr. J. Patnaik, Land Council, appearing for the applicant, let the matter be listed on 25th of August 2022. Mr. R.S. Chimankal and the Senior Standing Counsel appears for the revenue.
For orders item number 1.
Yes.
Dismissed for non-constitutional on 25/4/2020.
So there are private respondent opposite parties, so you have to issue notice.
But not admitted.
Oh, it was not admitted.
Not admitted.
Then, Mr. Muduri, we restored the matter. You have filed within time.
Yes. No notice has been issued in writ appeal.
So therefore, there was no appearance. We can restore it now. Heard Mr. S.C. Nath Sharma, Land Council, appearing to the seeking restoration of the WO number 706 of 2020, which was dismissed for non-prosecution by the order dated 25/4/2023. It has been stated by Mr. Nath Sharma and Council that the appeal was also not admitted and no notice was issued on the correspondence.
706 of 2021. As it appears, it has been filed by Odisha State Civil Supplies Corporation.
No, he says that no notice was issued.
No,
Appeal-
706 case number may not be correct.
Oh, acha, 2021, okay.
No, that as it appears,
just-
it has
just
been
I'm
filed by
checking.
Odisha State Civil Supplies Corporation versus Sitanshu Shekhar Patnaik.
WA
2020.
2020. I have written 21. Huh? 2020, it's right. We written a 2020.
Yes, 2020. Correct.
Right. Mr. P.K. Mudali, learned Asian government advocate, however, is has appeared for the opposite parties number 1, 2, 3, 4, 1, 2, 3, and 4 on advance notice. Stuff. We have perused the explanation given for not attending the proceeding by the counsel for the appellant on 25/4/2023. Stop on the day. The appellant's nephew's Shuddhi rituals was there. As a result, the learned counsel did not get an instruction. Stop. Be that as it may, we think that the retapping should be restored accordingly it is ordered by recalling the order dated 25/4/2023. So the writ appeal being 706 of 2020 is restored to its original file. Stop. Let the matter be listed on first of September, no? Huh? 1st of September, because it will go to the now original bench. No, don't try date. You have to go to the assignment bench. It will be 18th September 2020. It's fine. Council, not the council, that is the client. Oh, no, this council they went to his village to attend the. Yes, you read the paragraph too, huh? Shuddhi rituals of a nephew who died on is a blank. When he died, who passed away? Eh? No, the Shuddhi ceremony of the nephew just stopped there. All right. I thought the clients. All right.